May I please, my lords?
Yes.
So this is a matter where I've challenged the non-compliance of the provisions of 148A(b), my lords.
Yes.
The
Yes.
chance of a hearing was not
Correct.
given.
Correct. The same which is
Same, my lords. So the same similar matters have been kept to the 29th of June.
June. All right. Taken
That
on
is
board notice. He accepts notice. There will be no coercive steps till the next date. List on 29th June.
Along with WPC 8217 of 2022. That was a lead case, which
All
was the day before yesterday.
All right. 8217 of 2020.
Further proceeding.
Right. This is 6 and 7.
This is 6 and 7. my lords.
Ha.
But I'll only pray this further proceedings and pursuant to 148.
All that stayed.
Man.
Ha. What about 8?
8, my lords, is a 148. Your lordship may kindly turn to annexure 1 at page 17, my lords.
Yes.
Annexure 1 at page 17, my lords.
More than 6 years.
More than 6 years, my lords. And this
Covered. Ambika Iron.
Now the Supreme Court has
No, with great respect, my lord, Supreme Court covers, yes, Supreme Court covers those assessment orders, notices which were issued after 1/4/2021. Your lordship may kindly see, my lord. Let me place that Supreme Court judgment, please.
Para 11.
yes, Your Lord.
The present order shall be applicable pan-India, and all judgments and orders passed by different high courts on the issue and under similar notices which issued after 1/4/2021 issued under 148 are set aside and shall be governed by the present order and shall stand modified. What has happened?
But prior to that, Your Lordship, ornament provision also mentioned.
Your lordship may see the operative portion and the facts of the case. Your lordship may kindly come to paragraph 1, which was engaging your lordship. Take sir. Feeling aggrieved, may I just place it, my lords. Paragraph 1 at page 4, my lords. What was the issue before the Honorable Supreme Court, my lords? Lordship got it, my lords?
Yes.
Feeling aggrieved and dissatisfied with the impugned common judgment and order passed by the High Court of Judicature at Allahabad in W tax number so and so and other allied writ tax petitions by which the High Court has allowed the said writ petitions and has quashed several reassessment notices issued by the Revenue issued under section 148 of the Income Tax Act 1961 on the ground that the same are bad in law in view of the amendment by the Finance Act 2021.
Correct.
Which was amended by the Income Tax Act by introducing a new provision, that is sections 147 to 151 with effect from 1st April 2021. The Revenue has preferred the present appeal.
Correct.
So all notices, even though under the new act,
Because we waited, it didn't take us.
yes.
Because we adjourned it. We waited to see the outcome of this.
So my lord, all notices, even though it was issued under the old provisions after 1/4/2021, my lords,
Correct.
would be governed by this, my lord.
Correct.
Because the common argument before the Honorable High Courts was that since it was after notice was issued under the old provision after 1/4/2021, 148 of the old act will not apply, my lord.
Correct.
That with the lordships.
Correct.
That's why the lordships, if your lordship would kindly turn to paragraph 30, page 31, my lords, the operative portions,
And they use Article 142 in fact.
my lords. And they said,
To avoid any further appeal.
my lords, they said all these, may I just place it now, there are 4 directions, my lords.
Right.
The impugned section 148 notices issued to the respective assessees, which were issued under the unamended section 148 of the IT Act, which were the subject matter of writ petitions before the various respective high courts, shall be deemed to have been issued under section
No, let us
148.
hear. Let us hear him. Let us hear.
I'll just complete one more. Here, the notice itself is prior to 1/4/2021, my lords.
That's right. Let's hear him. Please.
Lordship, kindly have a glance, paragraph 8, turning page 26.
Right.
Lord, may I place the whole paragraph?
Yes, yes, please.
However, at the same time, the judgment of the several high court would result in no reassessment proceeding at all, even if the same are permissible under the Finance Act 2021, as per substitute section 147 to 151 of the IT Act. The revenue cannot be made remedialess, and the object and purpose of the reassessment proceeding cannot be frustrated. It is true that due to bona fide mistake and in view of the subsequent extension of time by various notification, Revenue issued the input notices under 148 after the amendment was enforced with effect on 1/4/2021 under the on amendment section 148. That is not the most important. In view of the same, ought to have been issued under the unamended act and ought to have been issued under the subsequent provision of section 147 to 151 of the act as per the Finance Act 2021. Therefore,
Ought not to, sir. In our view, you're hurriedly reading. In our view,
The
the
same.
same ought not to have been issued.
Unamended
One
act.
minute, please.
Yeah,
1 minute, please.
Yeah, not
If all of us, no, if all of us start talking, no clarity.
I'm sorry. I'm sorry.
Only one person will talk at a time.
I'm sorry.
In our view, the same ought not to have been issued under the unamended act and ought to have been issued under the substituted
yes,
provision.
yes, my lord, yes.
You cannot issue under the substituted unless you issue after 1/4, sir.
My lord, thereafter, my lord, thereafter. Therefore, appears to be there is genuine non-application of the amendment, as the official revenue may have been under bona fide belief that the amendment may not have been enforced. Therefore, we are of the opinion that same leeway must be shown in the regret which.
Correct, correct.
High Court, therefore, instead of quashing status and reassessment
Exactly.
notice on the unamended provision of the Act, the High Court ought to have been passed an order constructing notice issued under unamended Act, unamended provision of IT Act, as though.
That is, if it is after 1/4, sir. But so if it is after 1/4, all high courts will, whether or not it is issued under the amended, will assume it is issued under the amended. That's what he means.
But my lord, he say all this,
The crucial date is 1/4.
yes, my lord, that I understand, but later on, my lord, if I want.
Which is why the last paragraph,
But if I go
it
to the-
says that only those notices which you issued after 1/4 will be saved.
Yes, my lord.
Ah,
But my lord, if you go, my lord, by whole the judgment, it's, my lord, understand is what I, my lord, subject to correction, lord. It says, my lord, hold the notice, because 9,000 appeals, my lord, it paragraph 11 is, my lord, says, my lord.
no, let me ask you a different question.
Sir.
According to you, in all these cases, all the income tax orders have been upheld, notices have been upheld by the
Yes, my
judge?
lord, by virtue of this.
No, nothing has been set aside.
And to be applied.
Nothing has been set aside. Which means these appeals should have been allowed? All the high court judgments should have been set aside?
No, partly allowed, not this.
No, why is it partly, sir? If what you say is right, that this applies to all notices, whether after or before 1/4/2021, everything will be deemed to be under the amended act. That's your argument.
Yes, no.
If that was true, then the high court order should have been set aside?
Yes, my lord, that is the,
No, it is not, sir.
the 12, my lord, paragraph.
No.
Common judgment order passed.
No,
by
no,
High Court.
please see, it's partly allowed.
Yes, partly allowed, my lord.
Why is it partly allowed, sir?
My lord, the,
If what you say is right, it
Yes.
should have been fully allowed.
we also observe that present orders shall govern the
You
pending
have to carefully,
litigation.
which is why you have to
Pending
carefully
litigation.
read. You have to carefully read para 11, sir.
Yes, ma'am. May I read again? Not
Yeah,
subject to-
please.
But I also,
Correct, correct.
today morning I gave the order, so.
No, no problem.
Para 10, my lord, Lordship, kindly see. my lord. Para
In
10,
the
the
present
operative
order-
portion. Maybe there are certain observations.
1 minute, sir, 1 minute. Yeah.
The present order shall be applicable pan-India in all the judgment and orders passed by different high court on the issue under which similar notices which were issued after 1/4/21.
This is the most important line, sir.
Yes, ma'am.
After 1/4/21.
48 are set aside.
So wherever the high courts have interfered with a notice issued after 1/4/21, those orders of the high court are set aside, which is why it's only partly allowed.
Yes, Lord. The present, then Lord, may I place me the law subject to your lordship, Lord?
Sir, we are allowing you to keep reread, no problem.
Not like that.
We will always be enlightened by you, sir.
No, sir.
No, certainly.
Are set aside and shall be governed by the present order and shall stand modified to the aforesaid extent. The present order is passed in excess power under Article 242 of the Constitution so as to avoid any further appeals by the revenue on the very issue by challenging similar judgment order with a view not to burden the court with approximately 900 appeals. We have observed that present order shall govern the
9,000
pending
appeals, sir.
litigations.
9,000.
Sorry, 9,000. It's a pending with the High Court in which similar notices under 48 are issued after 1/4/21 under challenge.
Again, issued after. So twice they're saying issued after, which is why they're partly allowed.
Yes, ma'am.
All right, you say
And your lordship.
the court has been shown the judgment dated 4th May 2022, passed by the Supreme Court of India in civil appeal number 3005/2022 and batch bracket Union of India versus Ashish Agarwal, where the issue taken up for consideration was the correctness of the orders passed by the high courts of Delhi, Rajasthan, Calcutta, Madras and Bombay on the question of the validity of notices issued by the department, income tax department, bracket department, under section 148 of the Income Tax Act 1961, bracket Act, in light of the amendment by the Finance Act 2021, which introduced the new amended provisions, that is sections 147 to 151, with effect from 1st April 2021, paragraph. On reading the entire judgment, it becomes clear that the Supreme Court only partly allowed the appeals of the Union of India and made a distinction between notices issued by the department on or after 1st April 2021, and actually they should have said on or after. They only said after.
After.
This will have another set of problems. I think they meant on or after.
On or after.
On or after.
Maybe printers devil.
First, I'm sure somebody, some lawyer is going to say mine is 1st April, this is after 1st April.
There are certain notices, my lord, which were issued on, shown to be issued on 31st of March, but served on much after
That will not.
But in para 3.1, here
Yeah.
will not reference all these
Issued
notifications.
on or after 1st April 2021, and those that had been issued prior thereto. Full stop. As regards the notices issued after 1st April 2021, the Supreme Court has in its operative portion held as under, reproduce the whole of para 11.
Para 10.
No, 11, sir, 11.
I'm sorry.
Para 11.
Yes.
Consequently, the Supreme Court has in para 12 ordered as under, reproduce the whole of para 12 paragraph. In the present case, the notice under section 148 of the Act pertaining to assessment year, bracket 2014-13-14, was issued on 30th March 2021, that is prior to 1st April 2021. It is beyond the period of 6 years after the expiry of the AY in question. Consequently, both in light of the judgment of the Supreme Court in Union of India versus Ashish Agarwal, Supra, and the judgment of this court in Ambika and Steels, just put bracket order dated so and so.
May I just give a similar order?
The impugn notice is hereby quashed.
And
So now on that other day, which July,
July 11th. my lord.
all this will go now.
No, there are certain specific variations, my lord,
Aye.
which the Honorable Supreme Court may not have.
We'll see it on that day.
My lords. No, TK. So the subsequent assessment orders and the penalty notices. to
And
be
all
quashed.
the subsequent
And the
orders and
order
proceedings are hereby quashed.
or assessment orders and
Proceedings, orders and proceedings are
Order
hereby quashed.
question, penalty automatically enforcement.
That will also, my lord, sorry for the interruption.
No, TK.
And I beg pardon for that, my lords. This is not necessary. My lords, Supreme Court in that judgment, what you will find they have also laid down in the manner in which these notices will be issued. And that will make us the task easier
Right.
for the.
I hope they said, have they said anything on 148A?
Yes, and they have.
No, have they said to be heard? That is one more batch.
That is for your lordship's consideration, my lord.
That batch is growing. Today it has grown 1 more inch.
That is for your lordship to decide, my lord.
We'll be busy with that one.
Sincere.
So you people will be busy anyway.
No, because the lordship would appreciate in this 149 objections, the Supreme
Yes.
Court has left open that these can be also raised.
I see.
Because that will again bring in the question of limitation.
Correct.
As per the new act.
Correct, sir, correct.
One other aspect, Lord, which with great respect, Lord, the Honorable Supreme Court has not considered, even though powers under 142 has been assessed. If a lordship would kindly turn to page 13, the first two extensions were by the act of the parliaments, my lord.
Right.
The subsequent were for the CBDT. So that has not been considered.
All right.
So
All right.
if your lordship would appreciate, if your lordship would, because that, no, that,
Anyway, you'll argue it sometime in July.
Another thing, my lord, this is the first time I saw the Supreme Court has legislated. They have-
No. In numerous matters they have, sir. 142 is a
Yes, wow.
L. Chandrakumar.
Yes.
What can be more legislation than L. Chandrakumar?
Yes.
Yeah.
No, yes, reading fiction.
Yes,
Me
yes.
too.
Yes.
That's
Yeah.
very fast.
No, no, 142 has for a long time been, including 356 President's rule having to place before Parliament, it's all under 142.
To wriggle out of all this, 142 has been used. No, with
Right.
great respect.
Now you are 148A.
Obliged.
All right.
Greatly obliged, my Lord.
Thank you.
Sorry for interrupting my friend, my Lord.
I am sorry.
No, not at all. It's a pleasure. Obliged, my Lords.
All right. Thank you.
For judgment item number 1, CB REV 179 of 1995 and CB REV 274 of 1995.
The Two revision petitions are allowed. The impugned orders passed by the appellate court are set aside. Since two appeals against the same judgment have been filed, it is sufficient that one alone is heard. Accordingly, TA number 58 of 1994 is restored to the file of the learned ADJ Bhubaneswar for being proceeded on merits in accordance with law. It will be listed there for directions on 4 July 2022. Till such time the appellate court passes an order on the application for interim relief, status quo as ordered by this court will continue. The civil revisions are disposed of in the above terms. The LCR, if requisition, be returned forthwith.
And I am deeply obliged.
Fresh admission item number 2.
May I please your lordship? I'm on BC matter. It is for restoration of the ARBP number 60 of 2018, dismissed for default on 1/10/2021.
Order for reasons stated therein, the order dated 1/10
1/10/2021.
is set aside and arbitration petition 60 of 2018 is restored to file. Now, what is the matter there?
Therefore, appointment of arbitrator, my lord.
No notice went on it.
The notice was served and it was for final disposal.
All right. In view of the restoration of the present petition, notice without process fee be issued to the lawyer earlier, advocate who earlier filed vakalatnama on behalf of the opposite parties.
And
The appeal of the date, that is 8 July.
oblige, my lord.
Number 3.
I am appearing in DC.
Yes, please.
This is application under 11(6), read with section 14 and 15. The original applications, these are pending before arbitration, state arbitration tribunal, my lords, since 2098.
Oh, I see. There is already an order that we've passed in similar matters. The
My-
tribunal itself has been abolished.
Yes, my lords, it is not functioning. Only one member is.
Who's for the opposite side?
It is.
They're coming up for the first time.
Yes, yes, my lords. It is
All
coming.
right. Notice returnable. 24th June.
My lords.
Both matters.
Three matters are there.
Three matters. All right. Notice returnable 24th June. All right.
Okay, my lords.
Item number 6.
Lords, I am appearing for the petition, Lords.
Mr. Devraj Mohanty, I saw him.
Millers, I am instructed to
Ah.
appear, Millers.
Ah.
Here is the case, Millers. No contract is entered between the parties and no work order has been issued, Millers. Only LOA, on the basis of LOA, he has filed this application. Let the copy of the petition be served.
All
and
right.
I will
Notice,
file it
Mr. Mohanty accepts notice for the opposite party. Reply if any be filed within 4 weeks, rejoined up for the next date. List on 15th July. All right.
on. Millers, along with B Ponda. Millers.
All right. All right.
Supplementary list for orders item number 7.
May I please, your lordship? Lordship, I am in custody since 21/10/2020, lordship. In the meanwhile, I have been twice released interim bail and after
Lordship, may kindly see the last order. Your lordship has directed PO to get the status report of the trial.
What's the status report sent by the report?
The
Where's
last occasion, one witness has been examined, your lordship, in the last hour, your lordship. One witness is in examined, your lordship. I also.
1 minute. 1 minute, sir. 1 minute. Let me read it. So by end July, it will be complete, sir. So I'll keep this in August. The report of the third additional session judge Baleshwar has been perused. It states that the examination of witnesses is expected to be completed by end of July 2022. Full stop. In that view of the matter, the petitioner is permitted to renew his application for bail in the first instance before the trial court after the completion of the examination of the witnesses. Full stop. The petition is disposed of.
Your lordship, subject to condition, if not completed within July, then I have to renew my prayer, your lordship.
All right, all right. Yeah,
That order, my your
yeah.
lordship.
Will be permitted to renew his prayer after after 31st July 2022, irrespective of whether the examination is complete or witness is complete. All right.
Oblige, Your Lordship.
Item number 8.
May I please your lordship? My lord, I am in virtual, my lord.
Yes.
My lord, offense under section 302, 376 of IPC.
Yes.
My lord, the petitioner is in custody since 30th/7/2020, my lord.
Yes. Has the prosecutors been examined, sir?
Yes.
Yes, my
In
lord.
fact,
I have already filed the depositions.
actually, the depositions have already been solved, my lord. Now the prosecution has in fact, my lord, based its case on the last seen theory, my lord. And the report, the witness who was in fact heavily relied upon, he has turned hostile.
Turned hostile?
Yes.
Oh, I see.
So in fact, as on
All
that,
right.
my lord,
All right. It appears that
None of the
is facing
witnesses-
facing trial for the offense under
Thing is
section
against me, Lord.
376, read with 302. IPC. From the key prosecution witness has been already examined.
yes.
Learned additional government advocate, additional standing counsel for the state on examination of the deposition of the key witness states that the key witness is in fact turned hostile. Paragraph. In that view of matter, the petitioner has made out a prima facie case for, has made an arguable case for grant of bail at this stage. He has been in custody since
30th/7/2020, my lord.
30th July 2020.
My lord.
The petitioner is directed to be enlarged on bail, subject to the satisfaction of the trial court, and subject to the additional conditions regarding restricted movement of the applicant beyond the limits of his usual residence, and to report to the local police station periodically. The trial court will incorporate these conditions in an appropriate manner in the bail order. The application is disposed of in the above terms.
The trial judge may not be also be influenced by the order.
Obviously, sir. Please.
Item number 9.
Please, my lord.
My lord, offense under section 376(34) and 354
I
of
can't hear
IPC,
you,
my
sir.
lord.
You'll have to speak louder.
My lord, the offense under section 376(2),
Yes.
354 and 34 of IPC, my lord.
Yes.
So far the present petitioner is concerned, my lord, the offense is not made out. As because, my lord, the petitioner
Sir,
neither facilitated
The offense is
the.
only under 376.
Yes, my lord, today.
No, has the prosecutors been examined?
Yes, yes, I have the copy, my lord. As per the noting, I have the copy.
You'll have to give it to him, sir.
My lord. My lord, after perusing the
Do
statement.
I also get a copy or?
Oh, my lord. Sorry, my lord.
What about you? You are now without a copy.
Yeah, I have the copy, my lord. My lord, it is a.
So you'll have to teach me ODI also.
My lord, I am reading, my lord. My.
No, no, even if you read ODI, I will not be able to understand, sir.
My lord. গত মঙ্গলবার দিন মুই আমার গাঁকু in that situation I'll be submit the translated copy.
Please do, please do. Counsel for the petitioner
Any sorted man.
undertakes to produce the translated copies of the deposition of the prosecutrix on the next date. So we'll have it next Friday, sir.
Yes, my lord. Oblige, my lord. Oblige.
List on 13th.
Item number 10.
Not I'm speaking about my lord. Not offense under section 492, 304B, 306 by 34 by IPC and 4 of the DP Act, my lord. In the meantime, material witness have already been examined, my lord. They have not supported the prosecution case, my lord. My lord, mother, brother, and uncle. My lord, in fact, there are total, my lord, 20 numbers of prosecution witnesses, my lord.
I see.
They have been charge sheeted, and out of which, as per the rejection order, my lord, page 15 of lordship may see, page 15 of the bail petition, the honorable, the learned trial court has stated that till date 12 prosecution witnesses have already been examined.
But now all have been examined.
Material witness, my lord, mother, brother, and uncle.
Yes.
Material witness, my lord, mother and uncle and brother of the deceased has been examined, my lord, have been examined. They have not supported the prosecution case, my lord. I have annexed the deposition.
When are you in custody?
And I am in custody since 26/8/2020, my lord.
All right. The petitioner is in custody, the applicant is in custody since
26/8/2020, my lord.
26/8/2020 and is facing trial for the offences punishable under section 498A, 304B, 306 read with 34 IPC. A perusal of the order passed by the trial court on 9th February 2022 rejecting the petitioner's bail application reveals that as of that date, 12 prosecution witnesses (PWs) had been examined. Stop. Counsel for the petitioner informs the court that as of date, how many witnesses now have been examined?
12, my lord.
Acha. Has informs the court that of these 12 PWs, the mother, the brother, and
Uncle, my lord.
uncle of the deceased
My lord.
have all turned hostile
My lord.
and have
Yes.
not supported the case of the prosecution. The learned AAC.
But there is one witness, my lord, Deji alias Krishna Jana. Here he is the prosecution witness number 13. She has not examined. She has not been examined.
All right.
But otherwise, other related witnesses have already.
This is not disputed by learned AAC appearing to the state. Full stop. Considering the above circumstances, the court directs that the petitioner be enlarged on bail, subject to the satisfaction of the trial court, with additional conditions restricting the movement of the petitioner beyond his usual area of residence and reporting periodically to the concerned police station. The application is disposed of.
Item number 11.
May I please your lordship. My lord, custody since 6/11/2020. Offense 395, my lord. My lord, all the co-accused person on the similar footing has been enlarged on bail. My lord. I given those order copy, my lord. He has been implicated on the basis of confession statement of the co-accused, my lord.
The offense is under 395.
My lord.
But there must be a.
My lord, what
antecedent.
I have gone through the case diary, my lord. The petitioner is having 4 number of criminal antecedents, and the informant has sustained 4 injuries, out of which 2 are simple and 2 are grievous in nature. He was also identified in the TI period, my lord.
And the person was identified in the TIP, my lord, including the petitioner, that is one Avar Meher. He had been enlarged on bail by this honorable.
No, that injured eyewitness has been examined.
Trial status has been.
Trial has not yet started, my lord.
Then let
Not
the
yet.
injured eyewitness be examined. Let the injured eyewitness.
My lord.
Counsel, the petitioner seeks leave to withdraw the present petition with the liberty to renew the bail application before the trial court after the injured eyewitness is examined. Disposed of is withdrawn with liberty as paid for.
Done. Item number 12.
This is an application for appointment of arbitrator, my lord. Annexure 1 is the agreement.
All right, notice returnable 15 July.
My lord.
Item number 13.
Lord, item 13, I am appearing for the petitioner through virtual mode.
Ah.
This is for appointment of arbitrator.
I thought you people were in settlement talks or something.
No, my lord, we tried everything, nothing worked out. In fact, our requests for cooperation in the process of appointment of arbitrator was outrightly rejected on multiple occasions, which is why we are now constrained to invoke this petition before your lordship.
I think Mr. P.K. Ratha was usually appearing.
Yes. That usually appears for me.
I don't know if anyone is appearing for him. All right, notice returnable 15 July, sir. All right.
In July, grateful.
Right. Right.
Item 14.
14, my lord, I am appearing for the petitioner. Last occasion, the lordship wanted to, for the judgments in favor that section 69 is not a bar for the unregistered form. I have given the judgment. I have given the judgment. I am giving citation 2006 SCC 659.
Kamal Pushp Enterprises.
Yes.
There's an even more recent judgment, I think.
More recent, also I've given both in 2004, 3 SCC.
No.
155.
More recent meaning in the year 2021. That's what means more recent.
Okay. 16 also.
There's a judgment on the section 69 Partnership Act. And whether an unregistered firm can still maintain proceedings. There's a very recent judgment of the Supreme Court. 2020, I'll find out next date, otherwise next sitting.
The other objection I had is section 21 is not complied.
Notice.
And
For that, I have given the reply. For that, I have given in the last affidavit which I filed on 23/3/2022. We have written to the post office, to the Calcutta, and also to the Jajpur. And the return is not sufficient to us, and they have not communicated because it's a very old document, 2016's postal acknowledgement. So the authority has to give the acknowledgement that they have received. But my contention is that in my petition, I have wrongly annexed the postal receipt before one page. That I have given in affidavit also. Page number.
So he's annexed it at page 77, but my categorical denial is it's not served upon me.
No, it is served. It is served. That's why they have entered into the MOU, and they have not. They have after accepting the notice. After many, they have taken many time. After 4 or 5 years, they have we both amicably settled, and we have entered into an MOU. And the MOU unfortunately was not carried out because of some reasons. So,
What is your claim, sir?
Claim was 17 lakhs, but in the MOU we have settled for 11 lakhs.
Why didn't you go for mediation and settle this?
In fact, out of the 11 lakhs, also 2.5 lakhs odd is already paid. So we have reached upon the settlement pursuant to your lordship entertaining the petition. But this relates to a motor, my lord, which is installed.
Correct.
The motor has turned out to be defective. So if he replaces or remedies the motor, we will pay the balance amount and be done with it.
No, that is not a MOU, my lord. Lordship, can we come to the MOU, my lord? MOU is at the preliminary affidavit they have filed on 21st January 2021. The condition is at page 6.
So you make an attempt at mediation. I think if people ever went for mediation.
We did not. We did not.
We don't just make one attempt at mediation. The parties will make one attempt at settling the dispute through mediation. Their respective representatives will appear before the mediation center at 3 p.m. on. You want to do it this side or that side?
That side. That side.
22nd June. 22nd June 2022. The report of mediation will be placed before the court on the next date, 15 July. All right.
Item number 15.
The council, Mr. S.K. Sangira died on second.
Yes, I am for the Bachchan for the opinion 1 and 2, my lord.
All right, all right. Counsel for the petitioners to make alternative arrangements. Counsel for the petitioner states the alternative arrangements have to be made. Or you want time? Time. Seeks more time to get ready with the matter. 22nd July.
Item 16. 16, your lordship, in the last occasion. Regarding that stamp duties and the larger bills was the 5 judges bench of the Honorable Supreme Court. It has not yet been. It has not yet been formed. Subsequently, also in case of that Intercontinental Hotel, your lordship has knows in 2022 January. That matter also referred to the same question. Unless it is confirmed by the larger bench, that cannot be issued. On the last occasion, my lord also.
You offer the opposite side. Why did you come this side?
That is the only question, my lord, has been raised. And it was also, the adversaries has also pointed out that defect, unless it is done. And that question to be decided by the Honorable Supreme Court. And in,
all right, we'll wait for the Supreme Court judgment then. I don't know when the Constitution bench is going to sit.
5 judges benches, what has been reflected in NN Global Mercantile case.
2 references.
All right, it is stated that the matter is still pending for the larger bench of the Supreme Court. Then we'll have it on 12th August. 12th August. All right.
Item 17.
Item 17, I pray for an adjournment on behalf of Janmajay Ray.
Counsel, the petitioners, who's for the other side? Sailesh Narayan Viswal, not appearing today. Counsel, the petitioner states he's in some difficulty today. 26th August.
Item 18.
Item 18, my lordship, this application is with regard to the appointment arbitrator, my lordship.
In the previous date, my lordship, my senior has already filed the counter. Today we are filing out agent. I'm serving a copy to him.
All right. What do you say in your counter?
The counter my stand is if the lordship sees the clause, that is
arbitration clause is my lordship at page 25, my lordship, annexure 1, my lordship.
Yes.
now the clause states in the event of any dispute, bidder or big buyer is necessarily required to represent in writing to the general manager sales of the concerned coal company who deal with the same in the period of 1 month from such representation. Thereafter, if required, the matter be determined by the director in charge of marketing of the concerned coal company. Any interpretation of clause. Now, they have neither approached the general manager.
That's all right. But all disputes arising out of the scheme or in relation to it's a separate.
That is what the stand we have taken in.
No, that's nothing. So you say, having heard learned counsel of the parties, what is the extent of claim?
More than 4 crores, I
4
think.
crores, more than 4 crores.
All right. We'll have a district judge or want a high court judge?
As your lordship please.
This is A.K. Mishra. Justice A.K. Mishra. Having heard learned counsel of the parties and without prejudice to their rights and contentions and merits of their claims and counterclaims, the court appoints Dr. Justice A.K. Mishra, former judge of this court, as the sole arbitrator to adjudicate disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the High Court Arbitration Center.
May it please. At 19. May it please this honorable court.
Yes.
Ms. Smith, kindly see the last order had directed for settlement in the or filing of counter. Settlement.
Since the settlement couldn't happen, your lordships can appoint the arbitrator. So there is no point in filing the counter.
Correct.
And I think this claim would be or the counterclaim taken together in excess of 10 crores.
I see.
So if I suggest, subject to your lordship's consent and with Dr. Justice A.K. Rath.
Yes.
My lords.
With the consent of the parties, you say since the settlement has not been possible between the parties and with their consent, the court appoints Dr. Justice A.K. Rath as the sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the High Court Arbitration Center. All right.
Item 20.
Item 20, my lord, appointment of arbitrator. Last occasion, one counsel appear and took time to file the counter.
My lord, I have instruction to appear, but I want some time to file the counter.
All right. Your lordship, last occasion also they have 7.
All right. Last opportunity to file a counter within 4 weeks, adjourned of the next day. 22nd July.
They are not appear also, my lord. Your lordship.
Now he's appearing.
Last occasion also appear, but no vakalatnama filed, my lord. That's why I'm saying.
He will be filing a vakalatnama.
My lord, during the course of the
learned counsel states that he'll be filing his vakalatnama during the course of the case. All right. Is it same for the remaining?
My lord.
20, 21, 20.
22. All 3 matters. All right.
Item 23. Item number 23.
AD not back from the sole opposite party. Pass over.
Item number 24.
I am 46.
Actually, they have filed a counter on 4th May.
You want rejoinder? Rejoinder to be filed before the next date. 12th August.
Item number 25.
This is an application for appointment of an arbitrator, my lords. The
Yes.
arbitration clause is at page 76. Lordship may kindly come to page 76. Clause 6.3.4, resolution of disputes. Lordship got it?
Yes.
If dispute or differences of any kind shall arise between the tender inviting authority and the successful bidder in connection with or relating to the contract, the party shall make every effort to resolve the same amicably by mutual consultations. If the
What's
parties-
your objection?
I have filed my objection that the dispute which has been raised by the petition, that is a pre-tender tender state dispute and no contract has been executed between the petitioner and the opposite party.
No, but this applies, no? These clauses apply even at the stage of tender.
No, this is a part of tender that has also expired.
That's a tender expiring is nothing to do with the arbitration clause.
No,
Sir.
arbitration clause, you Lordship may kindly see that clause. If dispute or difference of any kind shall arise between the tender inviting authority and the successful bidder in connection with or relating to the contract. So contract has not been executed between the parties. He is challenging.
No, but he is the successful bidder.
No. Opposite party number 4, his case is that the opposite party number 4 was technically disqualified.
No, who is the successful bidder?
Opposite party number 4.
May I be allowed to submit, my lords? May I be allowed to submit?
Yes.
Kindly come to page 114, that is Annexure 6. That is Annexure 6. This was an offer made by the opposite parties to me. I'll read it out. Your letter regarding willingness to supply the mentioned item as L1 approved rate of tender. With reference to your letter number so-and-so, we take this opportunity to offer you our revised best possible rate as per details mentioned below for the benefit of patients in the state of Orissa. This is what we wrote to the opposite parties. Now, Annexure 8 is the reply of acceptance. Sir, that is at page 116. Inviting reference to the above cited subject, this is to inform you that as per your letter dated 18/9/2021, the matched offer of L1 bidder is hereby accepted. Purchase order shall be issued as per the tender terms and conditions. So it's an offer made by the opposite parties, which has been
never issued. Purchase order has never been issued.
Which has been agreed to by me, and that has been accepted by the opposite parties. Now, what happened? When they did not offer the purchase order, I issued a notice under section 11, which they refused to answer.
No, what was the subject, your Lordship may kindly turn to page 117. That is the notice, your Lordship, subject, your Lordship can see. Dispute relating to the opening and acceptance of the technical bid of Messrs. Lupin Limited. That is his dispute.
That will be decided by the arbitrator.
Page 117, subject is dispute relating to opening and acceptance of technical bid. And in similar situation, Honorable Apex Court held, no, this is not arbitrable, and this cannot be, there is no arbitration agreement. Well, placing 2010 5 SEC 213. This arises out of Delhi High Court. If you Lordship may kindly turn to page 219. No, prior to that, page 218. Questions for consideration. Paragraph 14. On the contentions urged, two questions arise for consideration whether there exists an arbitration agreement between the parties. Well, we are concerned with the question number 1. You Lordship kindly turn to next page, page 219, paragraph 21. At the outset, what should be noticed is that there was no contract or agreement between the parties except in regard to contracted quantity of so and so for which an order was placed by BSNL, but that is not the subject matter of the present dispute. Bid documents did not constitute a contract or an agreement to enter into a contract. It was merely an invitation to make an offer. It informed the prospective bidders how they should make their bids, how the bids should be processed by BSNL, how contracts should be entered by placing purchase orders, and what terms would govern the contract if purchase orders were placed. Now, my lord, page paragraph 24. As per the scheme of the bid documents, there is a clear division of the terms that will govern the tender process and the terms that will govern the contract when the bids are accepted. One part regulated the tender process that led to placing of purchase orders. That part contained a provision as to what should be the forum of dispute resolution if there is a dispute at the tender or bidding stage. The other part stipulated the terms and conditions which will govern the contract if and when purchase orders were placed. That part also contained a provision as to what should be the forum if there was a dispute after the contract was entered into. Clause 30 of the instruction to bidders makes it clear that in regard to tender stage disputes,
the forum will be civil courts. Clause 20 of the general conditions, on the other hand, was intended.
Sure, there's nothing similar to clause 30, but.
Yes, your lordship, kind down to page 76, clause 6.35.2. All disputes arising out of this bid. So clearly it is mentioned the bid will be subject to the jurisdiction of courts law in Bhubaneswar, High Court of Orissa.
Yes. All disputes arising out of the bid.
So Article 226 is there. And not to arbitration. Arbitration specifically mentions that in connection with or relating to the contract, contract has not been entered into between the parties.
Yes, Mr. Panda.
Yes, my lords. My lords, first and foremost is a judgment of the Honorable Supreme Court, reported in AR 2003, which I'll be placing before your lordship. I have given copies of the same beforehand.
Where is that?
I have given copies. I have submitted copies long time back.
No, AR 2003?
AR 2003, page 4219.
219.
4219.
Do you have ARs here in the court?
No. 4219. I have given copies, my lords.
1 minute.
May place that judgment some more detail also. Can you next paragraph? Paragraph 25. Clause 1 of the general conditions of contract section 3 makes it clear that the general conditions of contract contained in section 3 of the document shall apply in contracts made by the purchaser for the procurement of goods. Clause 20 of section 3, that is the arbitration clause, makes it clear that arbitration is available in regard to any question, dispute or difference arising under this agreement or in connection therewith. Therefore, it is evident that the general conditions of contract section 3 and clause 20 therein providing for arbitration will not apply
All right, let's read this now. 2003. Yes, I've got the judgments.
Yes. Lacidum A, last sentence. Moreover, this is the exact question which your lordship is dealing with now. Moreover, when questioned whether letter and exchange of correspondence between parties pursuant to tender inviting notice inviting tender constitute a contract and an arbitration agreement can be read into the same by itself is in dispute, it is exclusively within the jurisdiction of the arbitral tribunal under section 16 to decide the said question. Now, kindly come to page 4022.
Yes.
Para 11. Keeping in view the law as settled by this court, the designate of the Chief Justice acting under section 11 of the Act and the division bench of the High Court in exercise of power under article 226 of the Constitution of both acted under a misconception of law and wrongly held that the disputes were not referable to the arbitration. The appellant sought reference of its disputes with the respondent company for adjudication through arbitration in accordance with arbitration clause in the alleged agreement arrived at between them. Whether on the facts mentioned above an arbitration agreement can be said to have existed by recourse to arbitration clause in NIT was itself a dispute is deserved to be referred to the arbitral tribunal in accordance with the arbitration clause. Section 16 empowers the tribunal to decide the question of existence and validity of the agreement. Now next is a judgment reported of 2008, volume 4, arbitration law reporter, page 81. I have given a copy of that also.
Sir, your copies are not here with us, sir. Anyway, tell us what the judgment is.
Yes, it says the tender document itself contains an arbitration clause and by reason of acceptance of the tender of the appellant by the PGI.
No. Here, come back to page 76.
76. 76.
6.34.2.
Yes, if the parties fail to resolve the dispute or difference by such mutual consultation within 21 days of its occurrence, then unless otherwise provided in the bid document, either the tender inviting authority or the successful bidder.
So there are only two parties here, sir.
Yes.
One is the tender inviting the authority, the other is a successful bidder.
Successful bidder. Now, once the opposite parties gave me an offer which I accepted.
No. In fact, your grievance is that it's been awarded to opposite party number 4. Now, how can you describe yourself as the successful bidder? You yourself are acknowledging that it was awarded to some other party and you're agreed to that.
Your Lordship, may kindly turn to page 1116. 1116. And then
they may have accepted, but they did not issue a purchase order. The purchase order went to opposite party number 4.
Yes. We don't know. At the time of filing
of course you know. Your notice itself says, I am agreed by your giving the contract to Lupin Limited.
Mukul Limited, that part is the dispute to be decided by the arbitrator.
No, but you are acknowledging that the contract has been awarded to some other party. That's what you're saying. In your notice to them, you're saying that, sir.
I am not saying that they have issued the contract to the opposite parties. I am saying they have accepted the technical bid of the opposite party. Number 4. Now, page 121. Your Lordship may just have a last look at page 121 of my notice, para 8.
Yes.
Till date, we have not received any form of communication or reply from your end to a revised offer via letter dated 7/10/2021, which was accepted. While LOI has been issued in respect of some other items, not this item.
Yes.
Figured in the tender document, no LOI has been issued in respect of item number 39. Reliable information has it that you are contemplating awarding a major portion of the quantity, major portion, not the entire contract, insofar as item number 39 is concerned to Lupin. I am not saying, I have clearly stated therein, till that date, no contract had been signed with OP number 4, and they were also not contemplating giving the major entire contract to OP number 4. My humble submission is that all these disputed questions of fact are to be gone into by the arbitrator. And suppose, Milords, let's take an example. If I had filed an application under 226 invoking the extraordinary jurisdiction of this honorable court, a stand could have been taken by the opposite parties that there's an arbitration clause.
That is a presumption of the petitioner.
Maybe it's a presumption or assumption.
Which is the second judgment you said, sir?
Second judgment is
2008 Arbitration Law Reporter.
Volume 4, page 81.
And name of the case?
Name of the case is Unici India Private Limited versus Postgraduate Institute of Medical Education and Research.
No, what is it?
Unici, UNISSI. UNISSI, within bracket India Private Limited versus.
This is a Supreme Court judgment.
Supreme Court judgment.
All right.
Now, this one last but not the least, another reported judgment of the Honorable Supreme Court.
Yes.
Of 2010. Reported in 2010, Volume 1, Arbitration Law Reporter 286. I'll just read a short portion of the judgment for your Lordship's convenience.
Now, what's the cause title?
Cause title is Timex International FZE Limited versus Vedanta Aluminium Limited.
Yes.
Held. The minute-to-minute correspondence exchange between the parties, all the conditions prescribed which had been laid down, awareness of urgency of accepting the offer without any further delay to avoid variation in the freight or other factors, coupled with the email sent on 16/10/2007, would clearly go to show that after understanding all the details and the confirmation by the respondent, the petitioner sent a reply that thanks for the confirmation just in time to go for the. All the above details clearly established that both the parties were aware of various conditions and understood the terms, and finally the charter was entered into a contract by the parties on 17/10. Further held, court is unable to accept the stand of the respondent, it is clear that if the intention of the parties was to arbitrate any dispute which arose in relation to the offer of 15/10/2007 and the acceptance of 16/10/2007, the dispute is to be settled through arbitration.
Right.
Offer acceptance. The state made an offer, I accepted it, and it was counter accepted by the state. So indirectly or directly, I also become a successful bidder along with the opposite party number 4.
All right.
And I am placing that 2010 5 SCC. I am placing paragraph 26. In
Yes.
that case also, Honorable High Court of Delhi appointed the arbitrator under 11(6) that was set aside by the Honorable Apex Court.
All right. All right.
Paragraph 26, a contract is entered in pursuance of the bid when a purchase order is placed by BSNL on a bidder by clause number so and so of instruction to bidder. When a purchase order is not placed, there is no contract or agreement, and if there is no contract or agreement, the terms of the general conditions, including the arbitration clause, do not come into existence. In other words, there is no arbitration agreement at all. BSNL intended to have arbitrations only where it had entered into contracts and there were disputes relating to such contract. It did not intend to have arbitrations in regard to tender stage disputes or pre-contract differences at a stage when there was no
No,
privity.
I think the only point he's making is if he's made an offer and you've accepted it, how can he say there is no contract?
That was not accepted. That was not accepted.
What is not
So
accepted?
that was, you know, kindly see that document.
Page 116.
Yes. First, you also can say our his offer, his acceptance, you also can say page 114. That was a conditional acceptance.
Maybe.
That was a conditional, you also can see. We claim just below the box, my lord. While we offer you the above revised rate of so and so per buyer, we claim for entire 100% tender quantity based on our past representation submitted to you.
All
So
right.
he claimed the entire quantity. Now, what is our reply? You also can see at page 116.
Yes.
Purchase order shall be issued as per the tender terms and conditions. Now, this condition, my lord, will get at page 66. My lord, we can go to page 66. Clause 6.23.1.
Yes.
Well, there we have stated that if more than one bidder will be selected, then the successful bidder, the contract will be awarded to the lowest evaluated responsive bidder for the entire tendered quantity or part thereof as per the discretion of the management. However, empanelment of other technically qualified bidders may be asked through negotiation to match with the L1 price for supply of bulk critical essential program items. The MD so reserves all rights regarding the decision of the in case of splitting in 2 and 3. The ratio of 70-30, 50-30, 20 respectively may be used for or a different ratio at the discretion of MD. So we have never accepted that we will provide you 100% purchase order. And that is also we have stated in paragraph 15 of our counter that since the petitioner submitted a conditional willingness to supply the entire tendered quantity, the conditional willingness of the petitioner submitted by letter dated 18/9/2021 was not accepted. Acceptance of the conditional willingness of the petitioner as submitted by letter dated 18/9/2021 would have been in utter violation of clause 6.23.1 of the tender document and also would have amounted to rejection of the selected bid of the opposite party number 4. At the cost of reputation, it is submitted that the conditional willingness of the petitioner by letter date was never accepted by the answering opposite parties. No supply order was ever issued in favor of the petitioner. Now, in paragraph 15 at page 17, third line, there we have stated that the LOI was issued by letter number so and so dated 1/12/2021 in favor of the opposite party number 4 L1 bidder. Similarly, the purchase order has been issued in favor of the opposite party number 4 L1 bidder by letter number 17479 dated 1/12/2021. As per the purchase order, the opposite party number 4 has started supplying the product since 29/1/2022. Well, I am placing one judgment only, that is 2010. This judgment has been relied upon by the Honorable Apex Court in another later judgment, that is 2018 volume 10 SCC 525. There also, arbitrator was appointed by the party concerned. That section 16 application was filed, that was allowed. Then in appeal under section 17 to the High Court reversed the finding. Then ultimate matter came to the Supreme Court. Supreme Court set aside the order holding that there is no arbitration clause in the agreement.
May I make a small submission, my lords?
Yes.
It has been repeatedly stated by my learned friend representing the state that my offer was not accepted. If I read the language of Annexure 8, which is a letter of the state government, I fail to understand the tone and tenor of my learned friend's submission, which categorically says, your offer is hereby accepted. Emphasis.
All right.
Now, taking your lordship to section 4 of the Contract Act. What does it say, my lords? Communication when complete. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Here is a proposal which they gave, I accepted, and they communicated back that it has been accepted. So the communication is complete. Now, whether the opposite party should have been accepted, whether he should have been given X amount of the contract or Y amount of the contract, this is not a factor to be gone into by this honorable court at this stage under section 11. That part is to be adjudicated before the arbitrator.
All right. Here, that notice for appointment of arbitrator is challenging the selection of the opposite party number 4.
I have always challenged it throughout, even during the course of the tender. Then you made that offer which I accepted.
Right. Orders reserved.
Only may I place that 2000 BSNL judgment, paragraph 32 may I place, because there section 7 and section 11 of the Arbitration Act has been taken into consideration.
I'll examine.
Right. Yes, ma'am. My lord's order is also there, interpreting self-same clause also. My lords have rejected the arbitration petition.
All right.
Which one? What is that?
You have to give him copies, sir.
That is order dated 29/10/2021, passed in ARBP number 31 of 2021.
Is it redredging?
Yes, same clause. Same clause was interpreted.
Is the party redredging?
No. Some vision
spring.
Because a similar order was delivered by this honorable court in Reach Dredging versus Paradip Port Trust. Now the matter is pending. It is sub judice before the honorable Supreme Court, which has issued notice and pleadings are complete. There also the contract had not been signed. And I was appearing for the petitioner before this honorable court and also in the Supreme Court.
All right. Orders reserved.
Supplementary list item number 26.
Item 26, I'm for opposite party Puri municipality. We have instruction that they're in the process of settlement. So I pray another date may be given so that in the meanwhile there may be a settlement of dispute.
We have no instruction, but let them take
Council for the Puri municipality states that settlement talks are in progress. List on 26th August. My lord.
Quick cut, because our instruction is that no such communication has been made.
All right, 12th August. Item 12th August. Yes, ma'am.
Item 27.
27 is for appointment of arbitrator. Notice has gone. AD has not back, but delivery is confirmed.
Delivery is confirmed.
My lord.
You say none appears for the opposite party despite service of notice. What is the claim?
Claim is 1.53 crores.
The court appoints Sri Rao, will you be the arbitrator? Sri SS Rao, you are there.
I am for the opposite party on behalf of Mr. Lalit Maharan. I have to file so cause Wakalatnama has already been filed.
What are your instructions? Are you agreeable to arbitration or not?
I may be pardoned, my lord. I have no instruction on behalf of Mr. L. Maharana.
All right. Learned counsel appearing on behalf of Mr. M. Maharana states that he will be filing his Wakalatnama during the course of the day. Will you file it within the course of the day? Or?
Yes, ma'am.
All right. And praise time for counter affidavit. The reply we file within 4 weeks, rejoined for the next day. 26th August.
Orderly date, fellow.
All right, 5th August. 5th August.
Oblate. Item 28.
May I please, my lords, pursuant to this direction passed by this honorable court, requisites have been filed, my lords, on 26th of April. However, my lords, the noting says that the notices have been dispatched on 2nd of May and 30th of April respectively, my lords. 24th of April, this court was pleased to issue notice, my lords.
Because it's
26th,
too late.
Lordship,
It's too late.
Lordship, I'm appearing on behalf of the opposing party in this.
Oh, I see. All right.
I'm here.
Are you opposed to the arbitration?
I'm not opposing the arbitration, but Lordship, the amount is quite minimal. It's 92,000 as from them, but in the petition they have claimed 4 lakh rupees. Rather, we can send it to mediation, we can settle it out sitting
All
across
right.
the table.
Council of the parties
That's
agree
actually-
to explore the possibility of settlement through mediation. Their authorized representatives will appear before the mediation center at 3 p.m. on after the vacation or before.
Lordship, there's just one small request. Actually, the council, I am also appearing from Delhi, and the director of the opposite party is also located in Gurgaon. If it could be by hybrid mode, it will be quite convenient for the parties to appear.
All right, in
if
hybrid
it is possible.
mode. Yeah, in hybrid mode before the mediation center.
It can be after the vacation, Lordship, whenever
All right,
possible.
on 21st June at 3 p.m.
my
The
lords,
report of mediation will be placed on record by the next date.
Grateful, Lordship.
22nd July. 22nd July.
Item 29.
I am for the petitioner Miller.
I have
Last-
appeared for the opposition party. I have appeared for the opposite party yesterday. I will file my counter. Let it come after
All right,
vacation. I will file.
Mr. Barley appears on behalf of the opposite parties and states that he will file his reply within 4 weeks. Rejoinder of any before the next date.
Miller, interim order to continue till then.
Interim order to continue list on 29 July.
Item 30.
Milords, in item number 30, Milords, I appear for the respondent, Milord.
Yes.
Milord, unfortunately, we received a copy only yesterday in Gopalpur, Milord. I'm
All
appearing
right.
from Delhi.
All right.
So I
Mr.
will not be
Rajneesh
able to
Sinha.
assist, my lord.
All
I
right.
need 7 days time, my lord, to file the Vakalatnama, my lord, and also the counter.
All right. Mr. Rajneesh Sinha states that he will be filing his Vakalatnama within a week and reply within 4 weeks. Rejoinder before the next date. 29 July.
Grateful, my lord.
Item 31.
This is PK Das appearing along with the learned ASGI for the opposite party. Instructions are yet to be received, my lord. I pray, my lord, 2 weeks time may be given so that
All
we
right.
file our instruction or response.
Mr. PK Dash appearing for the ASGI seeks and is granted 2 weeks to seek instructions.
In fact, on the last occasion, they have admitted to appoint an arbitrator, but they have appointed their own officer. On 12.5, it's not permissible. Mr. Pari agreed that somebody from High Court will be appointed.
So 24th June. Have it on 24th June. 24th June, sir.
Yes.
Item 32.
Yes, my lords. There's item 32. As the notices have been sent, the noting says that item dispatch/received on 1st of May.
All right. This is capital region is Delhi.
Yes, my lords. My lords, that is a government of Orissa corporation. It's a
Oh, I see. I see. Okay, despite service of notice, none appears for the opposite party. What is your claim, sir?
Well, as the claim is 1.6 crores, but we also apprehend some counter claims from the other side.
We'll have a sole arbitrator as a senior lawyer.
My lords, a retired judge, if possible, my lords.
That will be a district judge, sir. Can't be a high court judge then.
District judge would be, my lords.
The court appoints. Sri Sarat Chandra Mahapatra, a former district judge as sole arbitrator to adjudicate the dispute between the parties, including their claims and counterclaims. The arbitration take place under the aegis of the arbitration set.
Password.
Grateful, my lords.
Pastor matter item number 23.
His Lordship.
The conducting counsel Surikant Dasmapatra unable to appear for this court due to medical injury.
Medical injury?
Yes, my lord.
All right. Counsel, the petitioner is stated to be injured. In any event, there is no proof of service of notice on the opposite party. Fresh notice by registered speed post be issued returnable 29 July.
Obliged, my lord.
This list is over. Special list. Special list for admission item number 1.
None appears to citizen opposition. The interim order is vacated. The order be communicated to the concerned court forthwith.
Special list item number 2.
None appears to citizen opposition. Same order. Interim order is vacated.
Special list item number 3.
My lord, item 3, no instruction, madam.
No instructions dismissed. Interim order is vacated.
Special list item 4.
May I please, Your Honor? May I please, Your Honor? Page 13, answer 2, cognizance taken by the magistrate is under challenge. As magistrate has no jurisdiction to take cognizance under section 3 of SC/ST Prevention of Atrocities Act, as special court being a session court is empowered to take cognizance. That is the my challenge. Can I have a glass?
This is correct. How can a magistrate take cognizance SC/ST Act, sir?
It should have been sent to the police station under section 156(3) for investigation. And a police officer of the cadre DSP, he should have investigated.
Correct. So how the magistrate can't take cognizance? SC/ST Act.
Of course, no.
That's obvious, sir. Give us the state judgment. The challenge in the present petition is to an order dated 15 July 2011 passed by the sub-divisional magistrate Khurda in ICC 1CC case number 401 of 2010, taking cognizance of an offence inter alia under section 3 of the SC/ST Prevention of Atrocities Act. Paragraph. In terms of the judgment of this court in Udaba versus Gora Bindani 78 1994 CLT 865 and Tina Krishna versus Sunanda Behra 2003 26 OCR 319.
But pardon, last week I'll pass it over. There's a latest judgment of the Supreme Court. I'm just finding it. It can be done. It will not be vitiated.
SC/ST Act taking cognizance by the SDJM.
On that, no, sir.
The criminal proceeding under SC/ST Act is not vitiated merely because the magistrate had taken cognizance and committed the case to the special court.
We are giving judgment.
Or it pass over.
Let it be taken up next week. So I shall go through that.
Or at the request of counsel of the parties.
Sangula Ashok's case, the Supreme Court has also said so.
What?
That the magistrate cannot take cognizance.
Cannot.
Yes, cannot.
That's what I thought.
Because commitment has to be done.
All right, at the request of counsel the parties. List on 13th. 13th May.
Yes.
All right.
Item number 5.
None appears. This is non-prosecution. The interim order is vacated.
Special list item number 6.
May be yours. The petitioner is the brother-in-law of the deceased Miller. The case under section 498, 304B, 306, 34 of IPC. Lordship, I may be permitted to raise all the points at the time of framing of charge.
Correct. Counsel, the petitioner seeks leave to withdraw this petition with permission to raise all the pleas urged here at the time of charge, framing of charge. Dismisses withdrawn, disposed of is withdrawn with liberty is paid for. The interim order is vacated. The order be communicated to the court concerned forthwith.
Special list item number 7.
None appears. Dismissed non-prosecution. Same order. Interim order is vacated.
Special list item number 8.
May I please, Your Lordship, my lord, on behalf of Mr. Vicky Ragada, my lord, I am placing that, my lord. My lord, in this case, passing of the FIR, my lord, offense under section 395 of IPC and 2527 of Arms Act, my lord. Kindly peruse, my lord, petitioner number, page number 3, Para 7, my lord. Para 7 and 8, my lord.
No, what's the ground?
The ground date, my lord, kindly see, my lord, page number 7, my lord. That the petitioner respectfully submit that while the matter stood thus since the present case is pending against the petitioner, they decided to settle the dispute between themselves at the intervention of the will wisher of both the
This can
parties.
be pointed out to the court concerned, madam. We say, permitting the petitioner to urge all the grounds raised in the present petition at the appropriate stage before the court concerned. The petition is disposed of, the interim order is vacated. The order be communicated to the court concerned forthwith. All right.
Specialist item number 9.
None appears, dismissal non-prosecution, same order.
Specialist item number 10.
Same. Dismissal non-prosecution, same order.
Specialist item number 11.
My lord, on behalf of HN Mahapatra, item to pass over.
All right, pass over.
Specialist item number 12.
May I please your lordship, my lord?
Yes.
Let it be, my lord, I can raise these things before the court, my lord, during framing of charge, my lord.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to place all the points urged here before the court concerned at the stage of charge. Disposed of is withdrawn with liberty is paid for. Interim order is vacated. The order be communicated to the court concerned forthwith.
Obliged, my lord.
Specialist item number 13.
Please, dear.
Yes.
Lord, this is a case where my application to seek representation through counsel has been rejected.
Oh, I see.
Lord, the petitioner before your lordship, my lords, he is an industrialist located at Singapore, having business interests in Orissa, my lords.
Yes.
The complaint was filed against him, and in that complaint, my lords, without issuing summons, warrants were issued. On coming to know of warrants having been issued, the petitioner had moved for representation at 205. That was rejected, against which I have come up before your lordships. And my lords have been pleased to stay the issuance, stay the further proceedings as well as the execution of NBWs.
What's the guarantee that you will appear, sir?
I'll appear, my lords, on the date fixed for recording of accused statement, and on the date of judgment, I'll appear, my lords. I am based in Orissa, my lords. The Juniwalas, my lords, they are the.
So why don't you appear on one day and then you can be exempt after that?
Lords, right now I am in Singapore. There is a travel restrictions. The Singapore government doesn't permit me to come.
Even now?
Yes. Even as of today, my lords, restrictions are there for travel, my lords, because of COVID.
I thought international travel is opened up, Mr. Panda.
My lords?
International travel has opened up.
Oh,
I know someone who traveled via Singapore to the US only last
right,
week.
my lords. I am also traveling to the US on the 28th, my lords.
Via Singapore?
No. Singapore government is not giving that facility to the residents of Singapore. They can't come back again.
I see.
Lords, appearance through counsel, this matter would have been solved by then. From 12, it is pending unnecessarily, my lords.
Who's for any objection, Mr. Katkia? Who's appearing?
Private parties. Private parties.
Private party has he been served? Has he been served?
Yes, my lords. Notice was issued and notice has been served on that. But none has appeared for them.
All right. None appears for the private respondents who are the complainants despite service of notice. Paragraph, all three petitioners are based in Orissa, but right now, all three are in Singapore.
No. Petitioner 1 is in Singapore, the others are here in Orissa.
And petition number 1 is in Singapore. Let the other two appear.
Lords, appearance will result in, my lords, asking for bail and other things. These are offences which are triable by a magistrate. They are triable under the summary procedure, my lords. What harm is there if counsel appears, my lords?
All right. The offences for which the complaint has been filed is under section 138 of the Negotiable Instruments Act 1888. The petition has been filed as a result of rejection by the learned SDJM. Q&J, is it?
SDM Pampos, my lords.
Pampos. of the application under section 205 CRPC for exemption from appearance. Paragraph. Having heard Mr. Devashish Pandal and counsel for the petitioners, the court directs that the three petitioners shall be permitted to be represented through counsel before the court concerned, where the complaint case ICC number 138 of 2011, court concerned, that is SDGA Pomposh, where the case ICC case number 138 2011 will be listed on 5th July 2022. Mr. Panda states that right now petition number 1, who is in Singapore, is unable to come to India because of travel restrictions. The concerned SDJ will pass appropriate orders requiring presence of the petitioners at the time of recording of the statement of the complainant.
Recording of statement of the accused members.
Statement of the accused, sorry, statement of the accused. The petition is disposed of in the above terms. Right.
Much obliged and urgent copy of that.
Okay, urgent copy be issued.
Specialist item number 14.
None appears. Dismissal non prosecution. The interim order is vacated. We communicate to the court. Yes.
Specialist item 15.
None appears. Dismissal non prosecution. The interim order is vacated. We communicate to the court.
Specialist item 16.
Item number 16, Lordship, I pray for one Passover, Lordship.
All right, Passover.
Specialist item number 17.
None appears. Dismissal non prosecution. The interim order is vacated.
Specialist item 18.
May it please your Lordship, I may be allowed to submit on meet, your Lordship.
Yes.
Lordship, in this matter, the petitioner is the injured from the alleged incident. Now, what has happened is there were certain accused persons who were left out of the first FIR, that is 192 of 2010, after the alleged incident occurred. Because of which the petitioner filed one 1cc application before the magistrate, citing the names of those persons and the evidences in that regard for them to be arraigned as accused in the present FIR. Now, what has happened, your Lordship, the petitioner has obtained this stay, this particular CRLMC, and obtained a stay from the Honorable High Court. A report may be called from the lower court, your Lordship, to ascertain whether the 1cc complaint, the accused in the 1cc complaint have been arraigned as an accused in the original FIR, your Lordship. Because it's of the year 2012, this report may be called for. That's all I'm saying.
Yes, Mr. Kadge.
I don't have any instruction guide. So the prayer is only so that the application with the prayer to stay the proceeding of ST number 51 by 2011. I don't follow what my friend is saying. You also can see the prayer. A very peculiar prayer has been made.
No, he is lodged in FIR 104 of 2012. Maybe it's a cross case. It's a cross case.
It's not a cross case, your Lordship. The first FIR has been lodged by me, and the second 1cc complaint also, the FIR has been lodged by me. And the injured in the alleged incident.
What should be clubbed off? I have taken.
It should be clubbed. My only prayer was before my Lordship that the accused persons who have been left out of the first FIR, they be arraigned as accused in the
that
was my one.
That there in the trial court 319 petitions should have been filed.
You can file an application in the trial court for that.
My Lordship may direct that in the order.
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to approach the trial court for impleading the left out accused persons in the ST case.
In the 1cc case, I'll give my Lordship the number.
Sorry?
The second PS case number is 104 of 2012.
Right. In PS case number 104 of 2012 at police station Bansada.
Oh, corresponding GR or corresponding city case number. An friend should have given that.
Anyway, disposed of is withdrawn with liberty is prayed for. The interim order is vacated. The order be communicated to the concerned court forthwith.
Specialist item 19.
Lordship in 18, if I may submit, your Lordship may direct the trial court to conduct the case expeditiously, your Lordship.
That you can make a prayer there, sir. You can always pray there. Yes.
Obliged, my lord.
Item 19.
None appears. Dismissal not possible. Interim order is vacated, be communicated to the court concerned forthwith.
Item number 20.
May I please, your lordship? Is it challenging the order of taking cognizance against the petitioner, your lordship may see annexure 3, page 77.
Sir, all these pleas can be raised at the appropriate stage. You see,
There, it has been clearly mentioned that they have not been charge sheeted. The petitioner is the advocate who identified in the cell deed, and the petitioner two is the advocate clerk who wrote the cell deed, my lord. And the handwriting expert has specifically stated that that is not the handwriting in the ROR, the handwriting of the.
all this matters go for trial, sir.
Yes, my lord, because
Reserving the right of the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated, the order be communicated to concerned court forthwith. Yes.
Specialist item 21.
None appears, dismissal non-prosecution.
My lord, item 21, conducting counsel has gone to Rajasthan to attend the court work at
It's
Jaipur.
all right, you tell me what the matter is.
My lord, kindly humbly pray for
No.
next week. My lord.
No. It's a 2012 matter.
My lord, certain, my lord.
It's all right. Reserving the plea, the right of the petitioner to raise all the pleas urged in the present petition at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. Right.
Specialist item 22.
The order be communicated to the concerned court.
May I please? The petitioner challenging the cognizance order.
Take her appearance.
Letter 17/7/2000.
Sorry?
17/7/2012 cognizance order, my lord.
Yes. What is the ground?
Both petitioner and the victim have married and staying peacefully.
This is Raghunath Sahu. Who is the petitioner?
Petitioner is the Sheikh Rajesh, Mr. Rajesh.
Mir Rajesh.
Mir Rajesh.
What is your report?
And
Yes, my lord.
164 statement.
My lord, at the time of registration of FIR, my lord, the victim was 14 years of age. My lord.
14?
Yes, no, my lord. He has given the affidavit, my lord.
Affidavit.
He has given the affidavit.
The FIR,
and he's
my lord,
18 years.
the FIR will also
18 years.
says, the informant
And,
alleges that her daughter is 14 years of age.
No, he has given the affidavit and offense is 363, 665 and 376 IPC.
Yes,
POCSO Act has not lost.
That's all right. Doesn't mean that.
Your lordship kindly see.
That's not proof of age. Where do we get the age?
He has given the Nagma Khatun age 18 years, annexed to affidavit.
She's made a statement under 164 saying she's 18 years.
18 years.
Yes. But my lord, since I'm just cited one judgment, my lordship sees, my lord, the Supreme Court 2015, my lord, 7SC 681, para 16 and 18, my lord. I'm just relying on para 18, my lordship, may kindly directly come, my lord. The aforesaid view was expressed while dealing with the imposition of sentence. We would like to clearly state that in case of rape or attempt to rape, the conception of compromise under no circumstances can really be thought of. These are crimes against.
No, they're married, sir.
But here in case also they were married, my lord. Here also married, my lord.
Where do you get that?
Yes, my lord, the subsequent two lines, my lord, there cannot be a compromise of settlement as it would be against the honor which matters the most. The sacrosanct sometimes solace is given that the perpetrator of crime has acceded to enter into wedlock with her, which is nothing but
agreeing to enter, acceded to enter into, not that they actually entered into.
but the intention.
They also have children. We don't know.
No instruction, my lord, but they married. The petitioner and the victim have married and residing peacefully.
Are you aware of this?
Reading.
Let him check. Counsel, the petitioner states that the petitioner and the victim are married and are residing peacefully as husband and wife. Counsel, the state wants time for instructions.
No interim order to continue.
Yeah, interim order to continue 20th, not 20th. 11th and opening, 24th June.
Yes.
No interim order to continue.
Yes, sir. Yes, sir.
Obliged.
Specialist item 23.
None appears, dismissal non-prosecution.
Specialist item 24.
None appears, dismissal non-prosecution.
Specialist item 25.
Lordship, the matter has been infructuous.
All right. Counsel, the petitioner states the matter is infructuous. It is disposed of as such. Interim order is vacated.
Obliged.
Specialist item 26.
None appears. Dismissal non prosecution. Interim order vacated.
Specialist item 27.
Same order. Dismissal non prosecution. Interim order vacated.
Specialist item 28.
None appears. Dismissal non prosecution. Interim order vacated.
Specialist item 29.
May I please? In 2010, my lord, OP number 2 as an informant lodged the FIR against the petitioner on the ground of kidnapping of OP number 3. Thereafter, he was arrested and released on bail by the order of this honorable court. Thereafter, matter was committed before the sessions court, and due to non-apprehension, NBW has been issued. And now in this petition, petitioner claims that the further development, they have married with the OP number 3 and they blessed with a son, male child.
All right. Counsel for the petitioner states that the petitioner and opposite party number 3 have since married and are blessed with a male child. Counsel for the state wants time for instructions.
Look, is there any stay order in this case? Was there any stay order in this case? Because the order sheet says that there is no stay order.
I have also no instruction.
Anyway, you take instructions, sir. There is a stay order. Interim order to continue list on 8 July.
Okay.
Pardon, my lords, item 28, my lords, I am appearing through the BC. My lords, my appearance could not be noted due to, my lords, some technical reason, my lords.
All right.
Item 20. Item
All right,
20.
all right, sir. All right, sir. All right. All right.
Specialist item 30.
Item 30, my lord, there is no instruction.
No instructions. Dismissed for non-prosecution. Interim order is vacated.
Specialist item 31.
Lordship, item 31, very innocuous prayer, Lordship. My FR, I want to withdraw, Lordship. Due to misunderstanding and miscommunication, the FR was lost. But I want to withdraw, Lord. That's the sole prayer.
All right. Mr. Delhi states he wishes to withdraw the present petition. Dismiss is withdrawn. Interim order.
Lordship, my FR before police station, I want to withdraw, Lordship.
All right. States that he wants to withdraw his FIR before the police station. He's free to make that prayer. The petition is disposed of. The interim order is vacated. Yes.
Lordship, Lordship.
Specialist item 32.
None appears. Dismissed for non-prosecution. Interim order is vacated.
Specialist item 33.
33, Lordship, no instruction.
No instructions. Dismissed. Interim order vacated.
Specialist item 34.
None appears. Dismissed.
I'm appearing, my lord, please. Your lordship.
Yes. Yes.
I am appearing, my lord. Your lordship is so fast. It is all. This is a case, my lord, the petitioner is a doctor.
Yes.
He is a doctor and he was serving in PPD hospital as a doctor, my lord. On the date of occurrence, he was in charge of emergency, my lord. On that day, at Bhubaneswar Capital Hospital, my lord. On that day, my lord, a patient was carried to the hospital, and this doctor, being in emergency charge, my lord, he referred the patient to the concerned doctor for treatment. Subsequently, she died, and a case was registered, and the principal accused persons have been acquitted. So, for this doctor is concerned, my lord, his only work was, his only job was, since he is in the emergency charge, whenever a patient comes and dealing with the odd hour, he will have to refer or make arrangement for some doctor. Except that, nothing, my lord. So in the main case, my lord, in the main case, there was some allegation of 354 or 376 or 302, they have been acquitted. So for this doctor is concerned, my lord, what is his evidence, what is the allegation against him? And the blindly, my lord, I must say, I'm sorry to use the word, the magistrate has blindly taken cognizance against the doctor under section 302, my lord, 354, SC/ST Act, everything. I'm not supposed to know whether he is SC/ST, my lord. And that apart, my lord, this doctor is undergoing a treatment, my lord, at Bangalore. I do not know whether he is dead or alive since long, my lord. I do not.
You better find out, sir. Counsel for the petitioner seeks time for instructions on the present status of the petitioner. List on 20th July. Sorry, 8th July. Right. Yes.
Specialist item 35.
I'm appearing in 35 minutes. In 35 arises out of I am in virtual mode minutes.
Yes.
Arises out of 138 of the Negotiable Instrument Act. If your lordship will kindly peruse order dated 16/1/2013.
Yes.
I have deposited the amount in this honorable court. A direction has been made to be kept in a separate account. 16/1/2013, my lord.
Can that amount be handed over to the other side?
Yes, maybe handed over, my lord.
Your Lordship, I'm for opposite part number 2. Your Lordship, we have already refunded the deposit. I found this from the file.
Refund?
Yes, we have already refunded.
I couldn't hear, my lord.
Yeah, she says they've refunded the deposit.
Your Lordship, Your Lordship, there is an order passed by this Honorable Court. By order that means case number 290 of 2014, order dated 11/7/2014. Your Lordship, you are directed to refund the amount. We have already refunded that.
No, that's right. The amount deposited by the accused along with the accrued interest be paid to the complainant. You have received it.
Yes, and we are refunded it also.
I don't understand. Refunding means what?
I am also unable to understand that.
What is refunding? You are the complainant. Why should you refund?
We are the opposite party number 2.
That's right. But it is the accused who is the petitioner here.
Yes, my lord. Accused is the petitioner here.
And you are the complainant. So why would the complainant refund? I don't understand.
Let's kindly give us 1 week of time.
What was the check amount, sir?
Millers?
What was the check amount?
Check amount was on 1,25,000.
So maybe she's accepted it and that's the end of the dispute. I think what she's trying to say is, or a counsel for the opposite party number 2 states that she needs time for instructions. List on 30th June, sir. No, not 30th June. Sorry, 8th July. Sorry.
Miller's interim stay to continue.
Yeah, interim order to continue. All right.
Obliged.
Special list item number 36.
None appears. Dismiss for non-prosecution. Interim order if any stands vacated.
Special list for hearing item 37.
None appears. Dismiss for non-prosecution. Interim order if any stands vacated.
Special list item 38.
Same order.
Special list item 39.
39 may please, my lord. In this case, my lord, the London Trial Court convict the petitioner under section 16 subsection 1A of the Prevention of Food Adulteration Act for a sentence undergo 1 year and fine 1,000 money.
Yes.
The present petitioner is the worker minor, not owner of the shop minor.
Mustard oil, sir.
Mustard oil and atta.
Mustard oil is the most problematic for adulteration. Both samples were adulterated.
My lord, I will give him the 15.
concurrent findings of both the courts.
Yes.
Since it is the first offense, so lesser punishment have been awarded.
Please give him a copy. Have you given him a copy?
Locksmith can see the appellate court judgment in paragraph 5 onwards. Those several points were all before the trial court, but in the appeal, the accused confined to 3 points only. May I please paragraph 5?
Yes, all the many points were contested.
All the many points were contested in the court of the land SDGM. 3 main points out in this appeal are first, that the case of the accused is not covered by the opening words of section 7. No person for himself or by any person on his behalf manufacture for sale or store, sale or distribute. 2, the sanction is not in accordance with law. And third, that non-compliance of Rule 9E of the Prevention of Food Adulteration rules. On the first submission, which was also read before the trial court and has been thoroughly dealt with in para 6, page 7 of the judgment, I have no hesitation to accept such finding. However, in support of said contention,
yeah, this have gone through. He's also in the shop selling it.
Yes. Though the son was the owner, but the present appellant, the petitioner was selling. And so paragraph 7, it is contended by the land council for the accused that PW4 is not the local health authority. Which
so here he's raising some other points apart from the owner point.
Yes.
He says the samples were not taken in clean bottles. Special messenger was not sent for sending it for testing. All these are new points.
Let's say paragraph 8. So a sample have been taken note of. It is now submitted that the third sample of the purchased articles was not produced in the court and there was a delay of 5 days by the signal.
No, that's a different point. Yes. Here he's saying the sample was not sent by a special messenger. And it was not taken.
So the same paragraph towards bottom, you also can say
just not taken in clean bottles. All right. You see, the present revision petition is directed against a judgment dated 5th August 2000. Passed by the Sessions Judge Kyonjar, dismissing criminal appeal 54 of 1993, thereby affirming the conviction and sentence awarded by the learned SDJM Kyonjar on 12/10/1993 in 2C CC 197 of 1987 under section 16(1)(a)(1) and 2 of the Prevention of Food Adulteration Act, bracket PFA Act, sentencing the petitioner to undergo rigorous imprisonment, bracket RI, for 1 year, to pay a fine of ₹1,000 and in default to undergo RI for 6 months. Paragraph. The background facts are that on 14/10/1987 at 11 a.m., the food inspector of Kyonjar visited the shop named Gayatri Store in Kyunjar Market and purchased from the present petitioner, that is the accused, 750 grams of mustard oil and 600 grams of atta. Full stop. The samples prepared from the said articles in compliance with the PFA Act were sent to the public analyst for examination. Full stop. Both samples were found to be adulterated. Full stop. After obtaining sanction from the local health authority, the prosecution report was submitted against the present accused. Paragraph. To substantiate the charge, 4 witnesses were produced, which included the food inspector bracket PW3, an employee of the Vigilance Department bracket PW1, the ADMO public health who accompanied the food inspector to the shop of the accused bracket PW2, and the chief district medical officer bracket CDMO bracket PW4. Paragraph. In para 5, the impugned appellate order, it is noted that although several points were raised, only 3 were urged in the appeal, namely: (1) that Section 7 of the PFA Act, which states that, open quotation, no person shall by himself or by any person on his behalf manufacture for sale or store or sell or distribute, unquote, does not include the present petitioner, who is not an owner of the store in question, shop in question. Next, 2, that the sanction was not in accordance with law, and 3, Rule 9 bracket small e of the PFA rules was not complied with. Paragraph. Before this court also, it is urged that the petitioner, not being the owner of the shop, could not have been prosecuted. Full stop. The appellate court has rightly repelled the said argument by pointing out that the expression single quotes person in Section 7 of the PFA Act would include anyone who sells adulterated food, and therefore the ownership of the shop is immaterial. Full stop. The court tends to agree with the above conclusion of the appellate court and rejects the above plea of the petition. Paragraph. As regards the non-grant of sanction by the proper authority, the appellate court has referred to the evidence of PW4, which shows that he actually went through the draft order and signed it. Exhibit 10, being the sanction order, revealed that the designation of the officer sanctioning the prosecution has been indicated as CDMO. With these findings being factual, the court finds no reason to interfere. Paragraph. As regards non-compliance Rule 9 bracket E of the PFA rules, the trial court, the appellate court has found that this was not mandatory and only directory. So that point is not even urged before this court. We'll stop here. Certain fresh points regarding there being no independent witness when the samples were taken, and about the samples not being taken in clean bottles have been urged. So these were not urged either before the trial court or the appellate court. And since they turn on facts, the court does not permit the petitioner to raise them at this stage. Paragraph. Having examined the concurrent judgments of the trial court and the appellate court, the court is not inclined to interfere either with the conviction or the sentence awarded to the petitioner. The revision petition is accordingly dismissed. The interim order, if any, stands vacated.
It is very old, my lord, 82 years old.
That's all right. Yes.
Specialist item 40.
May I be permitted to submit through VC on behalf of Mr. S.C. Mahanti, my lord, counsel
Yes.
for the petitioner.
Yes.
Here, my lord, this revision has been filed against the judgment of the learned additional sessions judge Balangi, confirming the conviction under section 16(1)(a) clause 2 read with section 7 clause 3 and 5 and Rule 50 of the Prevention of Food Adulteration Act, my lord.
Yes.
The prosecution's case in brief is that on 26th of May 1994 at about 10 a.m. in the morning, PW1, who is the food inspector, along with his peon, who is PW2, went for inspection to the locality, and therein they found that the petitioner number 2, that is Bhika Sahu, was running a shack and selling chicken items and tea, which was for display and I beg your pardon.
Yes, yes.
Which was for display and for being sold to the general public. Thereafter, they called for independent witnesses in the locality, to which PW3 complied, and he stood witness to the list of items to the list which was prepared by PW1 of the items which were there on display and were being sold. PW1, on demanding to PW2 the food license, PW2 could not comply with the same, because of which a list was prepared enumerating therein all the items which were there on display to be sold by the petitioners to the general public. Subsequently, my lord, it was found that on verification of the license registered, that a license register was there in the name of petitioner number 1, which was valid up to the year 1988. Therefore, though petitioner number 1 was not present during the time of inspection, he, along with his father, petitioner number 2, were arraigned as accused, and the prosecution report was submitted before the learned CDMO for grant of sanction. The prosecution examined 3 witnesses: PW1, who is the food inspector, PW2, who is the peon, and PW3, who is the independent local witnessman. The plea of defense was that of complete denial, and that the PW1 and 2 had never been for inspection on that relevant date of 26th of May 1994. My lordship, I had submitted the certified copies of the deposition during the hearing of the bail application. I do not have the legible copies of the depositions with me now, but if my lordship permits me to, in order to assist, may I point out the relevant paragraphs from the judgment where the depositions of the witnesses have been dealt with.
Yes, yes.
To begin with, the learned trial court has dealt with the depositions of the witnesses at internal page number 3, paragraph 6. At paragraph 6, the deposition of PW1, 2, and 3 has been dealt with, and at para 7, the inference has been drawn. If my lordship will peruse the same, or may I place the same before my lordship?
Yes, yes. What have you been sentenced to, and is petition number 2 alive?
Petitioner number 2 has passed away in the meantime, my lord. He died in the year 2004.
Okay.
Petitioner number 1 is alive, and he is a senior citizen now.
What is the sentence?
The learned first appellate court.
So we can apply the Probation Act.
My lordship, section 20,
that is
6 months, sir. They've been sentenced to 6 months and fine of 500.
That has been reduced to 3 months by the
3 months.
So you can apply the Probation of Offenders Act, sir.
That is prohibited.
My lordship,
Prohibited, is it?
in all fairness, section
20
prohibits.
What is his age now? Petition number 1?
Petition number 1 is about 64 years of age. But to assist my lord, in a similar case of conviction under section 7 of the Prevention of Food Adulteration Act, the citation, if I may supply to my lordship, AIR 2010 Supreme Court, page 1875.
This is only about selling without license, sir.
Yes, my lord. No.
It's not for adulterated article, Mr. Mudali.
Yes.
This is only selling without license.
Lords may consider, because I don't have the copies of those judgments, so I am not able to ask.
Say at the outset, it is pointed out that petition number 2 has expired. The appeal, the revision as far as he is concerned, accordingly stands abated. As far as petition number 1 is concerned, orders reserved.
My
The arguments have
lordship,
been.
if I may assist my lordship, there is a citation which I wish to supply to my lordship for
You can file it. Yeah, you can file it.
Therein it has been held that even if for charges under Food Adultery Action Act, in where the case was that of here also the accused had become a senior citizen and more than 27 years had lapsed. So the Honorable Supreme Court had considered these factors and thereby sentenced that period already undergone.
What has he undergone?
In this case, my lord, I'll have to verify from the records. But he was there behind the bar during the trial for some time. And even after.
You file a note, you say, the petitioner is prepared to file, is permitted to file a note of submissions. Within 3 days? Can you file it within 3 days?
By Tuesday, I'll file it, my lord.
All right. By Tuesday, 12th. Right.
Much obliged.
10th. All right.
Much obliged.
Specialist pastor matter item number 11.
May I please, Your Lordship? So here, my lord, I have filed this is my lord to pass the criminal proceeding, which is of the year
1986, my lords.
Yes.
It is a matter of 1986.
86.
Yes. FIR was lodged on 31st May 1986.
My goodness. What's the offense under?
498.
So you will urge all this at the appropriate stage, sir.
Your Lordship may kindly see Annex 2. In divorce proceeding, the same issue was raised, but the defendant or wife has not actually proved that there is a dowry demand or there is.
That's okay. All that means the trial will have to prove, sir. This is post conviction or what?
It is my lord.
No, this is original suit. Sorry. So you can urge all this at the appropriate stage. You say permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of, the interim order stands vacated.
Your Lordship, may NBW was issued, which was stayed. Your Lordship,
you can now appear, sir. You can now appear.
It must be more than 80 years old. It must be more than 80 years old.
80 years.
Yes, yes. It's all right, sir.
Your Lordship may say that I will surrender and so that I will be released on bail. Because
so that's a separate proceeding, sir. Not this is a 482. Don't combine these two things.
My lord, NBW was issued, my lord, by the Law and Trial Court. NBW was issued, my lord, which was stayed, your Lordship.
You also can see page 22. 22. Order dated 25th February 2011.
Repeated calls, no step is taken. All right. Counsel of the petitioner assures the court that the petitioner will appear before the court of the JMFC Nimapada on the date fixed by the court. His bail application will be taken up on the same day. Subject to the petitioner standing by the above assurance is directed to surrender before the JMFC Nimapada on 4th July 2022.
He shall be released on bail.
His bail application will be taken up for consideration on the same day. No further orders are called for. The petition is disposed of. The interim order stands vacated.
May I pray that he shall be released on bail, Your Lordship?
No, please. Yes.
Specialist pastor matter item 16.
May I please, Your Lordship? My lord, here the order taking cognizance is being challenged on the ground that it's barred by limitation. In fact, the FIR was lodged in terms of 468(2)(b) of the Code of Criminal Procedure. My lord, the FIR was lodged on 26/11/2018. Your Lordship will kindly turn to Annexure 1 at page 7. Your Lordship will kindly see the FIR was registered on 27/11/2008.
All right. What's the date of the offense?
The offense that is alleged was committed, my lord, on
26/11/2008.
2008.
8/8.
FIR was
26/11/2008.
How is it one day?
No, my lord, the charge sheet was submitted on 27. Your Lordship will kindly see 24/7/2010, page 18.
Yes.
And the cognizance has been taken thereafter, 31/2012.
Okay.
So my grievance was that since it's more than 1 year, so in terms of 468 2B, the cognizance should not have been taken. That has been turned down by referring to an authority, which will also kind permission. My associate may be permitted to produce that 2007 38 OCR Supreme Court page 309. That is what has been referred to by the Law and Trial Court to say that the cognizance can be taken beyond the period of limitation. That was a case where the court had, there was delay on the part of the court in taking cognizance. So therefore, in the context of the said fact situation, it was held that because there was delay on the part of the court, so the party should not suffer. The self-same decision has been referred to by this noble court, in the other case, that is 2010 47 OCR page 134. My lord, with your lordship's kind permission, may I just file that citation also? Therein, your lordship will kindly see this ground of delay and the paragraph 4, the same decision has been referred to.
All right. All right. All right.
The offenses were 341, 294. Here
Right.
186, 188 to 294, your lordship.
Right. Right.
And with your lordship's kind permission, I just beg to read the provision itself, which says that the period of limitation shall be 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. None of these offences visits with sentence more than 1 year. It is 3 months, 1 month, like that.
Right. Right. Yes.
So therefore, my humble submission is, my lord, this order taking cognizance is bad in law.
Yes, Mr. Katkia.
My lord. 468 was.
I think these are all minor offences.
Minor
Say
offences, minor.
petitioner has been, the FIR was lodged against the petitioner at PS Lakshmi Sagar, District Khurda, on 27th November 2008 under sections 188, 186, 294, read with 34 IPC. Paragraph, admittedly, these are all offences punishable with less than 1 year's imprisonment. Full stop. The further undisputed fact is that the charge sheet in final form was filed on
24/7/2010.
24/7/2010, whereas cognizance was taken only on 30th January 2012. So contending that this is barred by limitation in terms of section 468
2B, your lordship.
bracket 2 bracket small b of the Code of Criminal Procedure. The petitioner has filed the present petition. Full stop. The plea that the complaint was barred by limitation was negatived by the trial court by relying on the decision in Japanese Sahu versus Chandrasekhar Mohanty, 2007 38 OCR bracket SC 309 paragraph. However, on perusal of the said judgment, it appears that the decision was on the basis that the delay in taking cognizance was on account of the court and not on account of the parties. It was accordingly held that the party should not suffer for the action of the court. Paragraph, however, in the present case, the delay in initiation of the proceedings was on account of the complainant. So this distinction has been noticed in the subsequent judgment of this court in Amulya versus State of Orissa, 2010 47 OCR 134, where the decision in Japanese Sahu was noticed and was distinguished. Paragraph, in the present case stands on the same footing as Amulya versus State Supra. So accordingly, the impugn order taking cognizance, impugn order dated 30th January 2012 of the JMFC, of the SDJM, right?
My lord, of the
SDJ Bhubaneswar in GR number 4424 of 2008 is hereby quashed. Right. The petition is allowed.
Obliged, man. Obliged.
We'll return the books after the
My lord.
All right. 1 p.m. They're coming here or? All right. The office note has been perused. The correction be carried out as indicated.
Right. Item number 2.
Second copy is not there. You are all right. It may be taken.
No, steps for limitation not taken.
Barred by time, sir.
My
Barred by limitation.
Madam, I have explained that I was not aware of it. That's why I will file a limitation.
No, not like that, sir. It is already a 2020 matter.
Madam, I have filed it on. It was not listed. Well, I have filed it on 5/8/2020.
No. What is the order you're seeking review, recall of?
It was dismissed for default.
No, when?
Well, it was dismissed on 14/11/2019.
And you filed it only on?
I filed it on 5/8/20.
So more than 9 months later, sir.
That order was not that I am explained, my lord.
Where have you explained?
I was not aware, my lord.
No. When you file it 9 months later, how can you not be aware?
But paragraph 2, my lord.
Let's see that.
May I please?
Yes.
That in the application, the petitioner wished to state that on 14/11/2019, the matter was listed before the Honorable Court and the matter was dismissed for non-prosecution. It is most normally submitted that the advocate for the petitioner relies on the online.
What is the main matter about?
My lord, the order of Learned State Education Tribunal has been challenged in this case, where the past service of the petitioner for calculation for his pensionary benefit has been rejected, my lord. And similar circumstance persons, they have got the benefit, my lord. Only I pray due to my negligence, my lord, the petitioner may suffer only on merit. If it will be anything, what happens in merit, that won't go on me. It's due to my fault only this has been.
Will restore it, Justice Mahapatra?
Yes.
All right. For the reason stated, the application is allowed. The order dated 25th July 2019 is recalled, and it petition civil 127775/2013 is restored to file. The main matter released before the roster bench on 5th July.
Deeply obliged.
Item number 3.
My lord, matter relating to that resource teacher, the number of review petitions your lordship have allowed review petition in terms of the order passed by the Honorable Supreme Court, where the Honorable Supreme Court granted liberty to seek review of the order dismissing the writ petition. And in this case also, all those petitions were allowed. Review petition number 22 of 2021 had order dated 12/10/11/2021. Your lordship allowed the review and restored the petition for fresh hearing. And all those petitions have been taken up by the Honorable assigned bench. Here, in this present review, was a left out one. It was a left out.
In that restored writ petitions, they're still pending before the division bench?
Yes, madam.
All right.
3713, WPC 3713 of 2019 and other batch of cases.
When are they coming up?
Well, those were listed on 21st of April 2022, but next date has not been available on the website. But last date was 24th of April 2022.
Before which bench?
Honorable Justice Dr. Justice Sarangi and Honorable Justice.
I see. All right. You say for the reasons. We'll restore this also then.
Yes.
For the reasons stated therein, the review petition is allowed. The order dated
21/8/2019.
21/8/2019 is recalled, and writ petition civil 852 of 2019 is restored to file. It is directed to be listed before the roster division bench on the same date and along with writ petition civil 3715 of 2019 is listed. All right. All right, sir.
Yes.
Right, sir. Right. Sir. Mr. Ratri.
Supplementary list trace admission item number 1.
May I please your lordship, I mentioned dismiss for default, my lord, this honorable court. So
what's the main matter about, sir?
My name is Shankaracharya Chaudhary.
No, what is the main
case is dismissed for default, your lordship. That main
no, this is not the time for mentioning, sir.
No, you are my chief honorable chief justice and BP Rautrai court dismissed for default. So we have.
But it has to be listed, sir. No, right now we are in a list.
Yes, my lord. Several times I have given to the memo, my lord.
All right, this will come up on a Friday. All right. Next Friday. Next Friday. All right.
Lordship.
Supplementary trace admission item number 1.
May I please, lordship? During this case, my lord, so for the item number 1 is concerned. Item 1 and 7 both are connected. Yes, I am coming, my lord. So far, the item number 1 and 7 are both are connected, my lord. So far, that in item number 1 delay petition is there. That is also in item number 7, but it has not been that has not been mentioned to that extent. That has been in admission. If your lordship permit me, I am ready to argue, but limitation is there. So far,
tell us what is the matter on review, sir. Tell us that.
Yes, ma'am. Yes, ma'am. So far as this order which has been passed by your lordships, that is under challenge before lordship on 7/9/21, my lord. In specific ground, I have taken in my review petition, that is at ground number 1, my lord. My lord, may kindly see the judgment at page 14, my lord, which has been passed by your lordships, my lord. First of all, I want to draw your lordship's attention to the judgment which has been passed, to which I am want to review, my lord. At page 14, my lord. Got it, my lord? Yes, my lord. May I please, my lord?
Yes, please.
The Law and Council for the state, on the other hand, submits that the petitioners are irregular appointees and they even not completed 10 years of their service to be considered for regularization. Nevertheless, the government in their orders dated so and so have decided to take appropriate action for all such similarly situated 560 persons to accommodate them suitably. It is further submitted that no person junior to the petitioners have been accommodated by 8, my lord. To that extent, my lord, my rejoinder which has been filed by me by serving the copy on the council for the state, my lord, make a kindly see the rejoinder, my lord. I have specifically mentioned, got it, my lord? Yes. Page 2, my lord, of the rejoinder. My appointment is, which will clarify from Annexure 1 to the read petition 2 for 92, my lord. So far that this rejoinder which will placing before lordships 3 persons at the Prahalad Sahu, my lord, got it, my lord? His appointment is 13/11/98 and Harihara Pusti, that is of 26/6/97, Manoj Kumar Parida, that is 12/9/95. To that extent, my respectful submission before lordships, I kindly see annexure of the said rejoinder at page 3, my lord. So far as Prahalada Sahu, my lord, so his appointment letter, my lord. May I please, my lord? Yes. That is of 13/1/13/11/98, my lord. Then thereafter, my lord, the service book at page 4 of the first page, that is there. Then thereafter, my kindly see, after termination by the authorities, he took the shelter of the honorable tribunal, my lord. Then the government took the shelter of this honorable court, my lord. That is the order at page, relevant page is at 8, my lord. May I please, my lord?
Yes.
At page 8. Mr. Sahu Mr. Sahu Law and Council for the opposite party submits that issue involved in way number so arising out of which the present writ petition filed remains no more res integra, since the same has been challenged in the number of writ petitions so and so and dismissed so and so. On the last occasion, Mr. Mishra was asked to hand over the copies of the order of judgment so and so writ petition to the Law and Additional Standing Council for the state. Mr. Sahu, Law and Additional Standing Council for the state submits that the issue involved is covered by the order of judgment delivered on the aforesaid writ petitions. According in view of the above, the writ petition stands dismissed, my lord. Then thereafter they took the shelter of the Honorable Supreme Court of India, my lord. May kindly say at page 10, my lord. That SLP was dismissed, petitions are dismissed, my lord, accordingly, my lord. So far, the order which has been passed by the tribunal was confirmed. Then thereafter, I kindly see the at page 11. So far, the Prahalada Sahu That appointment is of 5/11, 5/1/19, my lord. Then there is another person I have shown to your lordships. So far, Harihar Prusti, my lord, at page 12, my lord. That is annexure 11, my lord. So far, Harihar,
they're all junior to you.
Much obliged. That is the only contention to that extent. My lord, that was not the ground while dismissing the writ petition. My lord, may kindly come to page 14, paragraph 6.
Page 14.
Yes. Page 14, that is part of impugned order.
Yes, yes.
The initial appointment order of the petitioner and subsequent orders extending their appointment from time to time do not show that the petitioners were appointed following the due procedure of selection. No document is produced on record to show that the petitioners have qualified through any competitive exam process. Their appointment orders further reveal that they were appointed on ad hoc basis for 89 days in each spell. So in absence of any material that their appointments were made through the valid process, no right accrues in their favor to question the retrenchment. The contention of the petition that some similarly situated persons.
In fact, this is not a new point. Para 7 also deals with all that. This is not a new point, sir.
So far, this resigned or to that extent.
No, all that is taken care of in para 7.
Yes, I have gone through that. To that extent, my lord, para 8, my lord. Kindly see.
No, if we have not dealt with it, we can entertain a review petition. We have dealt with it and taken
No, that is now with great respect to that extent. So far, these persons have not been dealt with.
No, para 7, sir.
That is similarly situated persons. That is not, they are not the juniors. My respect to.
But that's not the only point, sir.
No, to that extent, my lord, para 8 may kindly see. That is not also the ground of rejection of the writ petition. There, the rejoinder, my lord. Madam, kindly see in the rejoinder, I have clarified these are the junior persons. They have been appointed in 1997, 95, 98, my lord. They have been terminated like that of me, my lord. They took the center of the tribunal. Then the Honorable High Court government took this Honorable High Court. Then Supreme Court. Supreme Court dismissed and confirmed they have been installed to that extent, my lord. This being the position, if in other person, even just, my lord, in 2013, just I have also got an order. Similarly situated for more junior persons have also been direction has been given keeping the just recently to consider and to regularize the keeping in view the decision passed by this Honorable Court recently on 9/3/22, my lord.
It's not readable at all, sir. It's not readable at all.
No, to that extent, which lordship may place, my lord. Subject to action, my lord. It may place, my lord, so far as para 4 is concerned, my lord. It has been contended by learned counsel for the opposite party that challenging a similar order passed by the tribunal. The state has preferred writ petition so which has been dismissed by order number so challenging such order. The state has preferred SLP so.
Justice Rautre.
Mr. Mudli.
Yes.
If this Prahlad Sahu is similarly situating to the petitioners.
No, that was your lordship may consider in the impugned order, my lords have not dealt with so far as whether those Prahlad Sahu is junior or not. That is not the ground of rejection.
Saying. If
yes.
Prahlad Sahu, if appointed in 1998,
yes,
is junior to the petitioners. So it is to be seen whether this Prahlad Sahu, whose name was in the list,
yes,
as per the contention of the petitioners,
yes,
is similarly situating to these petitioners who have been irregularly appointed on the same department, on the same consideration. Is it so?
And if they are junior, see, if they are junior, then he has a plea.
Yes.
No, here minors.
Because in para 8 again, we again say the petitioners also do not dispute that any similarly situated person junior to them have been accommodated.
No, my lord may kindly see the next slide. Well, that is the conclusion of my lords.
No, but all Prahlad Sahu was also irregularly appointed.
No, since they all these persons were.
No, even those 3 persons were initially appointed without following any process of selection.
That I have to verify and file count.
No. In fact, even the Supreme Court, the SLP order says they were all irregularly appointed, but just see that SLP order.
At page 10, my lord.
Page 10.
Yes, my lord. To the appointments of the rejoinder, my lord.
For 10 of your rejoinder.
Much obliged.
The rejoinder order says, though the appointments of the respondents were irregular as they were not sponsored by the employment exchange, we do not intend to interfere in view of the long period of service rendered by the respondents. So they were also regularly appointed.
I will come back with this.
Or it will just say notice then.
In this case, sir, in this case, the petitioners have not come through due process of selection.
Correct, correct. That is the sole ground, my lords.
That will be sole ground. So if that Prahalad Sahu, who was also irregularly appointed, did not come
Yes.
through irregular,
Yes.
did not come through regular process of recruitment.
Correct, correct, correct.
And
So yeah. So if he is also junior and he also was not irregularly, regularly appointed, then this man has a case.
yes.
So we'll just issue notice. We say notice, Mr. Mudali seeks time for instructions. He accepts notice and seeks time for instructions. Both these matters.
Item
This
1 and 7.
1 and 7.
Not so obliged.
Next on 5th August.
Not.
Item number 2.
The matter was posted on 7/10/2021. That is the last working day of Justice S.K. Mishra, my lord. On that day, my lord, 4 cases of mine was listed.
All right. For the reason stated, the application is allowed. The order dated 7/10/2021 is recalled and red petition civil 20038 of 2014 is restored to the file. To be listed before the roster bench on 1st August.
38910 same on same day. 398,910.
Okay, 38910, all 4. All right.
Item number 4.
Lord, item number 4, I'm sorry, I'm in BC, Your Lordship. Your Lordship, 103 days delay, Your Lordship. Your Lordship, delay may be condoned because the review here, Your Lordship, is that one clause of the lease agreement has not been taken into consideration, Your Lordship. If that clause will be taken into consideration, Your Lordship, then Your Lordship has considered that the furnace is immovable property, can be treated as movable property, Your Lordship.
May I please
only one clause of the lease agreement, Your Lordship.
Which clause?
Your Lordship, that is at page 90 and 91 of the paper book, and I have quoted at page 6 of my review petition, Your Lordship. Page 6, paragraph 5 of my review petition.
Paragraph 5.
Paragraph 5, Your Lordship. Page
yes.
6. Open the unquote, the quoted portion, upon the occurrence of any default and at any time thereafter, the lessor would declare all future rentals due and to become due hereunder for the full terms of the lease, including any renewal thereof immediately due. And Your Lordship may kindly turn to next page. Page clause B, the last portion of the clause B. Your Lordship, I may not waste Your Lordship's time. The last 4-5 lines, lessor may detach and dismantle the equipment from any part of the freehold or procure machinery to which it may be affixed without the written permission of lessor.
That's okay, sir. How does that make a difference?
Your Lordship may kindly turn to page 45, page 44. Your Lordship's order, paragraph 27 and 28. Paragraph 27, Mr. Padhi, learned ASC also referred to the decision of Supreme Court in case so and so. There the question was about accessibility to excise duty on the ground, the assembling, installation and commissioning of asphalt drum hot mix plant.
No, the intention is to make it permanent, sir. The fact that it can be dismantled is different.
Well, let's see, next
the intention is to affix it permanently.
So Your Lordship, then what my respectful submission before Your Lordship is that, so that can be removed. Your Lordship,
No. Everything and anything can be removed. That's not the point, sir. The intention is to have it permanently fixed.
And also removed and can be sold.
No. It's all right. That's okay.
And Your Lordship, may kindly because Your Lordship, that can
No. This is not a ground for review. Sorry. You say court is not satisfied. Any grounds have been made out for review of the judgment dated 26/10/2021. Delay is condoned, but the review is dismissed on merits.
Yes. Lordships, I'm the liquidator of this. Thank you very much, my lords.
No. It's all right. Yes.
Item 5.
Item 5. I file same appeal seeking for restoration of the original equity. The matter relating to that bifurcation of that parent Panchayat Samiti and creation of a new Panchayat Samiti. And it was dismissed for default. Somebody else was the advocate on
31st March 2021.
All right, the reason stated, the order dated 31st March 2021 is recalled. Writ petition civil 8988 of 2017 is restored to file. Will be restored before the last bench on 2nd August.
As you know.
Item number 6. The miscase is slightly wrongly awarded for recalling and simply asking for an extension of the period because this sale was given land for 90 years by the state government.
Right.
But for railway use, they wanted to resume it back.
Right.
So your lordships, while vacating the order, had granted us time till end of February. So we just need, because your lordships know it's a central PSU, we have to follow certain procedure for disposal of all the assets and warehouse, whatever we have. So
Right.
till end of August only we'll comply with your lordship's direction.
All right.
Only till end of August if the time can be extended.
All right.
And so far as any rights arising of the agreement is concerned, parties can avail their own remedy through the.
Which is the order?
29/11/21.
My instruction is, your lordship has directed me to get instruction that they have not vacated the.
No, that's what I'm saying.
It's not vacated.
Yes.
Yeah.
That your lordship may kindly record that my
Yes,
instruction, I
yes,
have
yes.
written the instruction that
All right.
from the GA department.
We also admit that it is not vacated. That is why the
Right.
extension.
Mr. Nanda confines the learned senior counsel for the applicant, while not seeking recall of the order as such, states that the time for vacating and handing over peaceful possession of the land in question to the GA department may be extended till
end of August,
31st August 2022. Mr. Monty, learned AGA, points out that as per his instructions, the applicants have not yet handed over
Yes.
vacant possession.
Vacant.
Pursuant to the order of this one.
Yeah, pursuant to the order of this court, full stop. Paragraph, for the reasons explained in the application, and considering that the applicant is a PSU, central government PSU, the time for vacating the land in question, handing over peaceful possession to the GA department, government of Orissa, is extended till 31st August 2022.
Your lordships can also dispose of the writ petition, stating that if any other grievances of the parties, they can seek remedy under the contract, whatever they
All
have.
right, in writ petition, you say, in view of the above order, the petition is disposed of, leaving it to the petitioner to seek any other appropriate remedy. In any other remedy in appropriate proceedings. Right. The writ petition is disposed of. Right.
Item number 11.
May I please? Lordship would kindly see the order under review is at page 9. The issues involved in the present writ petition are similar to WP so and so in terms of judgment pronounced. The writ petition is also dismissed. Now, this was challenged before Honorable Apex Court. The order is at page 20. Honorable Apex Court has granted me liberty to file a review before this Honorable Court. Now, the Lordship take page 20.
Yes.
Now, after this liberty, I have filed this review. Now, if your Lordship would see the connected order, which is at page 12.
Yes.
Now, relevant portion on page 18. The principal reason why the petition was dismissed, if your Lordship could skip around 7 lines from top, para 15.
Yes.
In fact, the petitioner has admitted, Lordship gets,
yes.
Admitted in his rejoinder affidavit dated so and so at para 17 that petitioner undertook H&T operation fully aware of the stipulation of the lower rate, but from the beginning he has opposed the such change of condition with regard to lower rate and did not execute any fresh or supplementary agreement. Therefore, it is clear that being fully aware of the lower rate which may be stipulated in new contract, the petitioner continued to do the work for extended period.
So this fact is not there in your case.
No. In my case, there was no counter at all. So there was no question of this rejoinder.
Justice Rautre, should we place it before the roster bench?
Yes.
All right. The present review petition has been filed pursuant to the leave granted by the Supreme Court by the order dated 5th January 2022 in SLP civil number 12387 of 2021. The ground on which the review is being sought and which was pointed out to the Supreme Court is that the petitioners was a case of single court's extension, unquote, and different from the batch of cases which was decided by the judgment dated 31st May 2021 by this court. Paragraph, for the reasons stated therein, the review petition is allowed. The order dated 31st May 2021, the judgment dated 31st May 2021 in the present case, that is writ petition civil 16324 of 2018, is recalled and reviewed. So the review petition is disposed of. In the writ petition civil 16324 of 2018, you say the present writ petition has been restored pursuant to the order passed today in review petition number 67 of 2022. List before the roster bench on 9th August.
Grateful.
All right.
Item number 12.
Lord, in this case, we have filed a counter affidavit. Today, I am serving copy to him. It may be taken up next.
All right. Counter affidavit has been filed today. Rejoinder, if any, be filed for the next date.
My lord, your lordship directed on 18/84/2022 to keep one post reserved, but in the meantime, on 15/4, after 7 days, fill up the post. My
lord. How is that?
They have filled up the post.
Yes, sir.
So you'll have to file a contempt.
My lord.
Or what is all this?
I have no instruction. I have
All right.
They should not have.
All right.
Counter copy may be served on me. I am appearing for the opposite party.
All right.
Private.
Copies of the counter be served on all parties. Rejoinder, if any, be filed for the next date. List on 8 July. 9th August. 10th August. All right, Justice. Yes, sir. Right. Oh, Patnak. Yes, Justice Mahapatra.
Supplementary list for orders, item number 1.
May please, Your Lordships. Your Lordships, kindly have a glance on the last order. I am ready to file the undertaking for revocation, Your Lordship, 6 months. Last order. Your Lordships. My learned senior.
Yes. Mr. Chimanka.
Yes, as per section 80 of the Central Goods and Service Tax and Rule 158 of the Central Goods, the petition has to approach before the commissioner for installment. The order is passed.
All right.
Only my humble prayer, Your Lordship, that I have prayed for modification of Lordship's order. So what my learned senior is saying that if anything is due on my behalf, then I will approach the commissioners as invoking section 80. But this is only for modification of Lordship's order for RC revocation, Your Lordship.
No, we'll say notwithstanding our order, you can move. We'll modify our order permitting you to move.
Yes.
All right.
Within
the order dated 8/12/2021 passed by this court is modified by permitting the petitioner to approach the commissioner under section 80 of the Central Goods and Services Tax 2017, read with rule 158 of the Central Goods and Services Tax Rules 2017, if so advised, for deposit of the outstanding liability by way of installments.
So within a stipulated time, we will consider my case.
If the petitioner approaches the commissioner on or before 1st July 2022, such request will be considered on its merits and an appropriate order passed not later than 1st August 2022.
Okay.
All right. The application is disposed of.
For admission, item number 2.
May I please, Your Lordship?
Yes.
Here, Your Lordship will kindly recollect, apart from directing that the video clips of the locality should be produced by both the parties, it took time to file reply to the affidavit that was filed on 7/4/2022 by the Gale authorities.
Yes.
In page 3, at paragraph 6, they have stated that they have made it 2 meters deep and they have covered in order to secure. And the other aspect which Your Lordship will consider, I'll point out, I have filed an affidavit today. I have asserted that though I have not verified all the places while it was being laid, despite the fact that the review was pending, it is only 1.7, even not 2 meters, and there is no cover as stated by them in paragraph 5, that is having RCC slab and all those things. Apart from the above, your lordship has considered in this review application that initially their notification was that it should be 20 meters width, and they have in their affidavit by quoting the provisions that 7/4/2022 affidavit, your lordship will see it has to be it has to be 15 meters on either side. In total, the width is 6 meters, even not more than that. So therefore, it is quite unsafe to lead the pipe in between the road, which is only 6 to 8 meters, my lord. And they have, in fact, in the affidavit.
Why don't you come to that mic? You're for Gale, right? Yeah. So he's disputing. He says it's only 1.7.
Yes, my lord. I will take my lords first. If my learned brother has finished, I'll take my lords first to the affidavit dated 7th April 2022. Yes, my lords. My lords may come to para 5 of that affidavit, para 5 and 6.
Yes.
My lord, para 5 of the affidavit paraphrases the provision of 4.2.5 of the PNGRB regulations of 2016, which is at annexure 9 to the review petition, page 96. The relevant page is page 119. Yes, my lords may turn to the bottom of page 119. Bottom of page 119. May I please place it?
Yes.
No pipeline shall be located within 15 meters of any dwelling unit or any industrial building or place of public assembly in which persons work, congregate or assemble, unless it is provided with at least 300 millimeter of cover. Then my lord turns over to the next page. Over and above the minimum cover specified in table 3 or any other mitigation measures. My lord, this or is very, very significant in the context of the averments made by the petitioners. Or any other mitigation measure provided like higher pipe wall thickness. There is another or, my lord, this is also very relevant, or protection with RCC slab. No dwelling unit or permanent structure in any form shall be permitted within the ROU or ROW. My lords, may I please request my lords to turn over to the previous page at page 119, because the table referred in 4.2.5 is at the top of page 119, which prescribes normal or rocky terrain. This is the minimum cover requirement for pipelines. Serial number 1, normal or rocky terrain. 1.2 is the minimum cover in meters for normal soil. And my lord, the notes following that, note 1, is also very relevant in the context of this case. It says cover shall be measured from the top of coated pipe to the top of the undisturbed surface of soil at a distance of 2 meters or more from the edge or toe of ROU or ROW. Now, my lord, I take back my lords to para 6 of the affidavit, para 5 and 6 of the affidavit dated 7th April 2022. My lord has it? Do my lords have? Yes, my lord. My lord, para 5 basically summarizes the provisions of 4.2.5. At least 300 clause A, at least 300 millimeter of cover over and above the prescribed minimum cover of 1.2 meters. 300 mm would mean 0.3 meters. And clause B, any other mitigation measures like higher pipe wall thickness or protection with RCC slab. Then, my lord, at para 6, the mitigatory measures implemented in the subject area has been laid down. So, my lord, the first point, pipelines have been laid at a depth of 2 meters. My lord, I received the affidavit today. I have tried to portray it graphically for better appreciation. If my lord should permit me, I would place.
How will you hand over to Justice Mahapatra?
Uh,
Somebody should have been there in his court.
Yes, my lord, my actually associate has broken his leg, so I am handicapped today, my lord. Then there's.
I think Justice Mahapatra, shall we have it after vacation? Then we can sit together and. All right. We'll have it on the first Friday after vacation. We'll list on 24th June. We'll sit together. All right. All right. All right.
Item number 3.
This is that matter where, just a minute, in this case, your lordship may kindly remember, he is claiming that a portion of his private land has been occupied by the executive engineer for construction of certain work, and there was a measurement, and 23 decimal is found to be occupied by the government for, and review petition has been 28 decimal, whatever. In the review petition, we have said that so far as the title of the petitioner is concerned, that is now disputed, under dispute, and his vendor's lease has been cancelled, and the matter is now subject. So unless his title is finally adjudicated, we cannot give any compensation, because on one hand, it is treated to be a government property. On the other hand, they are claiming it is a private property. The matter is pending in a writ petition, which I have stated in my additional affidavit, and he has not given any reply to that categorically. He has stated many things. Only the very narrow point is that when the right title interest is sub judice in a proceeding, whether he can be compensated for that, that your lordship is to decide.
No, my lord. This is a Sthitiban plot.
Converted to Sthitiban in a later stage, originally acquired by
initially it is
that is the report of the Tahsildar. I am not saying that.
Tahsildar also give a permission to purchase this land in the 1993.
May I
without
pray one thing
without a piece of paper?
How then again hear the matter afresh, writ petition. Many controversial issues are there, because fate of this case depends upon many cases of that particular Jokolandi Mauja, and which matter is pending before Honorable Justice Vishwajit Mahanti and Justice P.R. Satpathy, and that is pending. So if I can only pray your lordship that if the writ petition may be reheard, he may be given opportunity to place all his materials, and
no, but we went through the whole thing, right? This is not a one-line order or something.
No. But my respectful submission before law, these things were not placed before the court. That may be the matches on the part of the state.
My lord, forcibly demolish my boundary wall and acquire and use my land as a road since 2012.
What is the explanation for this? This is the main point, right?
Without a piece of
without resorting to acquisition proceedings,
my land.
You occupied his land.
That your lordship may kindly, this is the road. A road has been carved out. He is saying that a portion of the road belongs to my private property.
Correct.
And there was a demarcation, and it is found that 20. But only thing is that the entire property which is now occupied by him, it was initially granted by virtue of a WL case in a lease proceeding, and his vendor's lease has been cancelled, and all these things now in a proceeding before the Honorable.
My lord, I am not occupied. I am purchased.
You are a purchaser from the original lessee. I don't say that.
That
original lessees are no more. Your lordship knows in Bhubaneswar, the original lease was granted to Tom, Dick, Harry, and they have sold it to many big people.
It is a Sthitiban plot.
Sthitiban, you after you purchase.
No, my plot is at Nayapalli.
No, the cancellation of the lease was after his purchase, correct?
Yes.
As on date, the property stands recorded in his name. So,
yes.
Survey Settlement Act, Section 13, there is a presumption with regard to his title. Until and unless it is set aside by a competent court,
correct,
he continues to be a valid owner of the land.
Correct. In his case, was there a cancellation of lease in his case?
That is my instruction in Jokolandi Mauja.
No. His
in particular case, in this particular, that is there in the additional affidavit. But if your lordship wants, I will produce the lease case record, where we can come to a specific conclusion with regard to the antecedent of the petitioners.
No. Is there an order cancelling his lease?
Yes, I understand your lordship. In that event, your lordship may give me some time. I will produce the record, because I cannot say this without the records. From the Tahsil office, I will, so far as this particular land is concerned.
That's right. We are only concerned with this particular land.
Yes, but in Moja, Jokolandi, they have been.
That we are not concerned with, sir. We are only concerned with this petitioner.
Yes, my
lord.
My lord, up to date rent receipt I have filed 6.
No. Only if there is a WL case in which lease was cancelled. We don't know that.
His vendors.
My lord, in my when I purchased the land, the Tahsildar also give permission to purchase.
All that is true, sir. We don't know. Many of these things happen without your knowledge. In fact, many of the subsequent purchasers keep coming to this court saying, without notice to us, the lease has been cancelled, and we are sending it back. In those cases, we are sending it back to the ADM to say, here this subsequent purchaser before you cancel the lease.
My plot is not cancelled.
That's what he wants to find out.
Mr.
D.K. Montil and AGA states that he needs to seek instructions on whether in this particular case, any order was passed by the ADM.
By the authority, your lordship.
By the authority cancelling the original lease.
Of the petitioner's vendors.
Or the original lease of the petitioner's vendor. At his request, list on. When are we having the other one? 23rd. 24th. June.
Obliged.
All right. Right, sir.